Please, your lordship, my lord. Am I audible?
Yes.
Audible but not visible.
My lord, it is not convenient, my lord. There is one item, 26 and 27.
Yes.
26 and 27. This application in item 27 for vacating of the interim order. IA 104. Now, I want to find objection to it, my lord. We want to objection to the application which they have filed. Who
is appearing along with him? Who is assisting him? What do you want? See, these are the problems we see.
Yes.
Sir,
item 26 to 31.
Yes.
All these items, in fact, all these items are connected.
You tell us.
no, in fact,
It's not clear.
yes, I'm not online. But in this, we want to file objection to the IA filed by the NHI DSL.
That's all.
So that's what I think my senior wants to
It's not you think, it's sure or not?
Yes, that's
You
what
are there. You
senior.
are with him.
See,
Is not it?
yes,
You are with him.
yes, sir.
Okay.
Senior advocate wants to have 2 weeks to file objection to this one.
2 days.
2 weeks.
2 weeks. Huh?
So this one.
My lord, in fact, state also has filed an IA, item 26. In fact, today was the day where we are supposed to file our report as per the order which we are seeking for modification. So in that event, if they are taking time, they have taken time in our IA also, in the IA of the NHRDC law. In the meantime, that the interim order may remain suspended in that event.
No, that we cannot. You have filed it for until we hear that. How can we just? I mean,
otherwise, they may say that on one hand they are taking time, on the other hand.
It's on their prayer only we are granting. It's okay, huh?
My lord,
Mr. D. Das, senior counsel for the WPC.
27, 576.
576 2025 submits that he may be, the petitioner may be allowed to file objection to the interlocutory application number 104 of 2026. Therefore, placed for 2 weeks time. List of who else are there for respondent?
I am for respondent number 5 and 6.
You have filed the application. You are the applicant.
Yes.
Prayer not being objected to by Mr. Arbi Yadav, Land Counsel for the applicant in the IA number 104 to ensure 2 weeks time granted. 2 weeks time as prayed for is granted to file objection. This the next para then.
Fix it later.
he is making some
interim
submission.
order, my lord, in my case.
Well, that's the problem, that the interim order.
Interim order passed earlier shall continue.
My lord, in item number 28 to 30, there were certain specific directions to be carried out by the state sponsors. There has not been filed also till date. This is the third time it's coming.
That is what he is saying.
Yes.
You are supposed to file report.
No, in item 27, we were supposed to file report.
You file it. What's there in the meantime?
Otherwise,
the very order directing us to file report, that is we are seeking modification.
Okay, then we'll see.
Therefore, interim order instead of.
So what about IA?
Status quo.
IA 92.
92 is our IA. So instead of saying that interim order.
Mr. Das, what about IA 92?
Well, we have filed an objection. They see only modification to the
No,
extent.
you want to You want to file objection in 104 or 92?
92 they filed.
No,
Okay.
104 I have fresh. 92 I have filed. 104
Okay,
I have
okay.
to file. So because they effectively filed. So let
Okay,
this matter
then we'll
come in the
say,
June first week, my lord.
Mr. T. Pertin, learned counsel for the writ petition 36, 79, 171, and who is for the 203?
203, Mr. P. Bora.
For learned counsel for the petitioners is present. And Mr. The N. Ratan Learned Additional Advocate General for the state respondents are present. Huh? List these matters after 2 weeks.
My lord, the fixed date may be given. There is, my lord, may instead of saying the interim order to continue status quo. my lord.
No, we cannot change it now.
No, no, no.
Sir,
my lord,
unless
you-
you have filed IA for modification. Until we hear it, how can we just pass the note?
Yes.
My lord, then fixed date may be given.
Fix that
15, Mr.
15 June.
15 June.
15 June.
June.
After 2 weeks, 3 weeks, 2 weeks on 15 June.
Sir, can it
Madam,
be? Yes.
item number 20.
Right. Okay. Deeply.
15 June. Obliged.
Yes, next.
And item number 20,
Yes.
30, they have not filed. They should file their affidavit, at least whatever they
Yes,
still
yes.
they want.
May I please, Lordship? I'd like to mention item 6. my lord.
Item 6.
Yes.
Yes.
I am for respondent number 2 and 3.
Hmm.
Some time may be given to file the affidavit of petition.
Gokul Prasad Sharma. What is the matter about?
Matter is regarding the bank has kept implied.
Okay, who is for the petitioner?
Yeah, I am for the petition.
Had Mr. What's your name, please?
El Kagong.
Huh?
El Kagong.
El Cargo, London Council for the petitioner. Next prayer. On the prayer of, is prayed for Mr. R.B. Yadav, London Council for the respondent number 2 and 3. Prayers for in is granted 3 weeks, 3 weeks time to file affidavit in opposition. Yes, next.
May I, Your Lordship? Lordship, I beg to mention item number 17 and 18, Your Lordship. This matter to be fixed on next week, Your Lordship.
Why?
Here we have already filed our counter affidavit, Your Lordship.
You have filed.
Yes, Your Lordship.
This is for what? Suspension.
Item number 115 is regarding challenging the suspension of the Lordship, even after expiry of 90 days,
There was no review.
not review.
Not really.
What is your stand?
Yeah,
They've just filed yesterday only, but I have
Yes,
not
sir.
yet received the copy till this morning.
Huh.
So, Lordship,
It is submitted by P. Pangu, London State Council, that an affidavit on behalf of the state has already been filed in both the
yes, what the cases, Your Lordship?
second 18 to it's release. There is already order of the court. Have you received the subsistence allowance?
yet not, Lordship.
Why?
In this matter, they have not furnished the certificate, Your Lordship. That one, that the petitioner has not engaged in any other employment, Your Lordship. In our affidavit, Your Lordship.
Where is this? Item 18 to once the court has directed to
Yes,
release the
yes,
subsistence allowance,
yes.
nothing remains.
Yes,
Final order has been passed.
Lordship.
Item 18.
They are not complying the order, Lordship. So, Lordship, let it be on, Lordship. May I humbly pray that
However,
28.
Mr. K. Lolet, Learned Counsel for the petitioner, submits that he has not been furnished with the copy of the affidavit in opposition. Mr. Considering above, the MSP Learned Counsel for the Learned State Council to furnish the copy of the affidavit in opposition to the Learned Counsel for the petitioner. List of list
28, Lordship.
Okay, Your Lordship, 28.
28. List them as agreed to by the parties. Let these matters be listed on 28. So,
28. For the matters, Lordship.
Obliged, Your Lordship.
My
But before that, if you have to submit some documents, you submit it.
Yes, Your Lordship. We have not submitted, Your
Lordship, I
Lordship.
have submitted already on 2 occasions before filing this writ petition also. And on the date
That
of
certificate that you are not
yes,
engaged in
not
some
engaged
other-
in yes any employment.
But
on 2
this
occasions,
court
Lord.
has already passed an order to release the subsistence allowance. What remains here?
Yes,
If they are
Lord,
not complying, you file contempt.
yes,
I mean, all you avail the remedy.
Your Lordship,
Yes,
in this
because
regard,
there
I
is
will
no
take
exception.
instruction, Your Lordship.
On next day, we would like to see that subsistence allowance is released.
Yes, Your
This is an
Lordship.
order of the court.
Okay, I will take instruction, Your Lordship.
Interim, it's not interim, it's a final order.
yes, Lord.
Your prayer is to release the for payment of the subsistence allowance. Okay, 28.
And Lordship, I beg to mention item number 32. Lordship, here I have received an instruction from to represent the private respondent number 4 to 9 just this morning. So Lordship, I may be allowed 2 weeks time, Lordship. I have informed the counsel for the petitioner also.
Mr. K. Learned Counsel for the Learned Counsel submits that he has an instruction to appear in this matter. On behalf of respondent number
4 to 9, Lordship.
429. He prays that matter may be listed after 3 weeks so as to for filing affidavit in opposition. Praise the Lord. List the matter after 3 weeks.
3 weeks, Your Lordship. Oblige, Your Lordship.
Deeply obliged.
May it please your lordship, I
Yes.
beg to mention item number 33 on behalf of Sri S. Thai, Learned Conducting Counsel. The conducting counsel is unable to remain present today due to unavoidable circumstances.
Why? What's wrong with him?
He is out of station, lordship.
You are ready?
My lord, I'm for the petitioner, my lord. My lord, this observation may be made,
What is
kindly
the
made, my
matter?
lord.
What
This
is the
may be
matter
the
about?
last chance, my lord.
What is the matter about?
Matter, my lord, pertaining to the eviction.
Hmm?
Eviction, my lord.
We'll no adjournment. We may not require to hear him also.
My lord. No, okay, my lord.
You take the second file, read it.
I-
We'll see. Madam, you take the second file. What is your affidavit? You see, you go through it.
My lord, otherwise, my lord, I have been informed over the telephone that this conducting council S. Thai is out of station, my lord.
Eviction, what's there?
My lord. So, my lord, last chance may granted, my lord.
No, you are not seeking adjournment.
My lord.
You may not require to hear the respondent. He's a private respondent.
Okay.
Any difficulty?
Of course, my lord, since I have been consented over the telephone and being the out.
So you are not ready.
Of course, my lord, from my side, my lord, I am always ready.
Always ready.
Yeah, my lord.
That's the spirit. That should be the spirit. Anyway, you have some reservation that your writ petition will be dismissed. Anyway, MS
Thopi Bomjen, T Bomjen.
Learned Counsel appearing on behalf of Mr. S. Thai, Learned Counsel for the respondent number
4.
Submits that Mr. Thai has some personal difficulty today. Therefore,
My lord.
praise for listing of the matter after 2 weeks.
No, my lord. May this letter be listed on 15 June. 15 June.
3 weeks.
Yes.
Then 3 weeks, make it 3 weeks. Please stop. Prayer not being objected to by Mr. C. Modi, then counsel by the petitioner. Apprehending that this the writ petition may be dismissed. Huh?
Not exactly, my lord.
Just delete that. Prayer for adjournment is accepted. As agreed to by parties, let this matter be listed on 15 June. Yes.
My lord.
Yes.
And my lord, I beg to mention item number 7, my lord. Here I am for the petitioners. My lord, matter become in praxis. So, my lord, I have been instructed to, my lord, withdraw. Matter pertaining to the election and the last election has superseded the my lord, bond of contention between the parties.
Okay. Mr. C. Modi, Learned Counsel for the petitioner submits that this writ petition has become in praxis. List of Accordingly, the writ petition stands closed on having been become infructuous. Please do.
Obliged.
Lordship, I will to mention item number 15.
Hmm.
Instructions yet to be received, Lordship. Some more time may be given.
15, arbitration,
Yes.
appointment of arbitrator. It has to be disposed of
Yes, Lordship. Maybe
expeditiously
taken next week, Lordship. Taken up.
next week.
Yes.
We'll grant you 1 week.
Yes, Lordship.
Mr. S. Iran,
Yes, Lordship.
counsel for the
On behalf of El
appearing on behalf of El Perme, Standing Council, Power Department, press for adjournment of the matter on the ground that Mr. El Perme has some difficulty today. Mr. Miss MS, you are
Yes, Lord,
no
Lordship.
objection.
No,
Yes.
no, yes. Dear lawyer, Lordship.
K lawyer, and counsel for the petitioner is present, considering that matter pertains to appointment of arbitrator, considering the matter, considering that the matter pertains to appointment arbitrator under section 12(11) of the Arbitration and Conciliation Act. Let this matter be listed after a week. After a week.
Yes, Lordship. Be blessed.
Item number 1.
Wait, please, Lordship.
Yes.
Uh,
Who is
uh,
for the respondent?
Kindly pass over the matter, Your Lordship.
Why?
The standing counsel for CGST is on the way.
You are for him or you are for petitioner?
No, I'm for petitioner.
Then? Where is? Where he is?
On the way.
After some time.
Item number 2.
May I please, ma'am?
Yes.
My lord, the nutshell of the case is, my lord, pertaining to the accord of my land in the building by the department, by the informant, that is the Legislative Assembly, my lord. Initially, my lord, this matter was, I was issued the show cause notice by the, my lord, state officer on 10 July 2024. And accordingly, in consequence of the show cause notice, my lord, I have replied and we have appeared many times. The hearing was conducted by the Deputy Commissioner. And ultimately, my lord, while conducting the hearing, my lord, it has come to the consensus point that the land of my building should be, my lord, acquired by the respondent, that is the, my lord, informant, with compensation, my lord, with a condition that I should be compensated as per the market rate. In due course of the time, after fulfillment of that proceeding hearing, that
What is the nature of the land and building?
my lord,
It's constructed on the government land.
my lord, it was constructed, and now the claim has been started by 2024. Whereas
Right.
my contention is that, my lord, I have constructed
Where
the
is the
building.
communication, impune communication?
My lord, impune communication is, my lord, in page number, my lord, 90. It starts from 90, my lord. My lord, got it. I am directed to report about the letter and referring to convey you the government decision. After the examination of the record, and it has been found that the building constructed one Sri Harish, my lord, it's me. The teacher is unauthorized in the illegal extension of the building. Firstly, the construction of the allotted government land. Secondly, the DC Capital Complex had served him the show-cause notice on the 10 July 2024, wide number such and such as to why the action shall not be initiated against him for the construction of the high-rise building without obtaining the developmental permission from the competent authority. Further, it has observed that he has violated the Arunachal Pradesh bylaws 2020, though he has claimed that he has constructed the building in years 2009. However, on the examination of the scientific data like Google's image, it has shown that he has constructed in 2013 onward, thereby violating the building bylaws and which is under the implementations in 2010. Under provisions of the bylaws, it is mandatory to seek the prior permit and developmental activities from the competent authority for taking up the building construction. Thirdly, the compensation amount of 6 crore 5 lakhs 25,000 and 179 and 179 page.
Is it your land is allotted? Land is allotted.
My lord, my case is my lord, my land was not allotted.
Then
So my lord, therefore my lord, that was hard, my lord. That
no,
hearing was
try to settle.
concluded.
They are so gracious, but then ultimately law would not permit.
My lord. However, my lord, what I am trying to project, my lord.
They would not have it.
My lord, that my land was not
not
allotted.
Nobody would have any issue if the government wants to compensate you, even if you are found to be illegally constructed the high-rise building.
My lord, the government has already accepted.
No.
And thereby
the approval? What's the acceptance of the government?
My lord, definitely, my lord, dear, my lord, may kindly come to the page number, my lord. This 48. It is a type out copy. This is the result of the parts hearing.
Who has done that? Who is the authority? Who has done that?
My lord, this is done by the deputy commissioner.
No, he doesn't until the government.
My lord,
has it been approved?
Yes, my lord, the government has approved him to, my lord, dispose of my matter, and accordingly the matter was heard by the deputy commissioner. My lord, may kindly come to
pay your compensation.
Page number 45, my lord.
45.
My lord. This is the result of the parts hearing, my lord. My lord, I would like to read it out from third para, my lord.
Where is the approval for compensation?
My lord, therefore, my lord, this has been an approval is, my lord, in page number, my lord will find in the page number 48. Because, my lord, this whether I have to evict or I have to compensate, my lord, that was decided, and accordingly, my lord, a committee was constituted.
Who has decided this?
And, my lord, this was decided by the deputy commissioner in presence of the, my lord, consented by the complainant, my lord. Now, accordingly, my lord, the committee was constituted, and as per the committee report, my lord, the report from the constituted committee is, my lord, the assessment is appear in page number, my lord, 48. In view of the order dated 20 January 25, my lord, the committee was constituted, and that was accepted by the government, my lord, and accordingly, this committee was constituted.
Who has accepted that? Who has approved the government means who?
My lord, mean this government mean, my lord, the department, legislative assembly, my lord. Legislative assembly, my lord.
Who has approved this?
And while hearing, my lord, this was represented by assistant and
okay,
the under secretary, my lord.
It doesn't mean that government has approved this. It's a government land you have unauthorizedly constructed.
Government has accepted, my lord.
Where it is accepted?
My lord, that is why, my lord, I am trying to show in page number 45. The committee was constituted.
It's okay. That is
this committee was accepted, and accordingly, this is the estimate of the government in page number 48.
Initially, they were gracious enough, but then they have realized that this is illegal. Then, therefore, you have to be evicted. That's all.
My lord, that is the contention of the government. What my contention is, my lord, in the world hearing, my lord.
Whether the land has been allotted to you.
My lord, to that extent, my lord, this is undisputed land. So far, my lord, land has not been allotted. And
Number two,
my allotment
whether
proceeding is still, my lord,
obviously,
pending.
unless you have the legally allotted, unless land is legally allotted, you cannot construct any house.
My lord,
Not to talk of high-rise building.
therefore, my lord, what I am submitting, my lord, that the government also, they accepted that while I was, after completion of my building, the government has started claim, my lord. That is why.
Unless you constructed a building, how can there be a illegal construction? You have constructed it illegally.
Of course, my lord, there has been many buildings in the state of Arunachal Pradesh with anticipation of the government for allotment of the regularized allotment.
I'm sorry.
Therefore, my lord, my allotment
But
was.
simply issue notice, nothing else. It doesn't deserve even a notice to. And this communication is internal communication.
Therefore, my lord, assessment was made from my side as well as from the government side. But the government side, the assessment is, my lord, 3 crores something. Therefore, that was accepted in the case, and accordingly, my lord.
Who has accepted it?
My lord, Deputy Commissioner.
Cannot.
And accordingly, Deputy Commissioner has
From where
forwarded
he
the
pay the
recommendation.
compensation?
My lord.
From where he will pay the company? From his pocket?
My lord, no, that is why, my lord, that the recommendation was sent to the, my lord, state government.
See,
Particularly,
one understand if you have been allotted the land for construction, construction of a house or building, and you have constructed. Now, if the government wants, then you may be entitled for compensation of the structures.
My lord.
In the case, you have unauthorizedly, you have occupied the land, government land, and not only unauthorizedly occupied, but also raised a high-rise building. What can we do?
Ultimately, my lord, in due course of the hearing, government also, my lord, accepted that I should be
What
compensated.
about the government? Some of the officers were there, doesn't mean it's a government. Finally, they have to approve it. Even if the government approve it, we would not like to accept that. That cannot be permitted.
And that assessment committee was, my lord, not only one, but twice, my lord.
Doesn't matter.
In the second.
Maybe 100 times. Facts remain that illegal is illegal. We'll issue notice only, at best. Although it doesn't deserve
notice issue. At the same time, my lord, I am praying for, otherwise, my lord, this matter is likely to be in practice. My lord, if the eviction notice is passed.
Obviously, what would be the recourse?
My lord,
no allotment was given to you. You have constructed illegally, unauthorizedly. Then what should be
that was already decided in the Deputy Commissioner, my lord, while hearing.
As an officer of the court, you just tell us. For a moment, you are not the counsel for the petitioner. Independently of the, just what do you say in such a case?
My lord, to that extent, my lord,
you agree?
My lord, agreed. But this case, my lord, there is
considering your
exceptional, my lord. Exceptional in my case.
Mr. Modi, by considering your fairness, you are just issuing a notice. Nothing more than that.
My lord.
Heard Mr. C. Modi, learned counsel for the petitioner, claimed to be aggrieved of the communication between the Deputy Secretary DA, Government of Arunachal Pradesh, and Deputy Commissioner Capital Complex Itanagar, whereby the government has intimating the Deputy Commissioner as regards the rejection of the rejection of the compensation purportedly assessed for illegally constructed high-rise building on a encroached government land by the petitioner, and consequent request to initiate necessary action against the petitioner under the as per the law for eviction, this writ petition is instituted. Next para. It is the case of the petitioner that the building constructed on a government land, which of course not been allotted, has been subjected to assessment for payment of compensation as agreed to by the departments through the Office of the Deputy Commissioner, Capital Complex, which consequently assessed the compensation for payment, assessed for payment of compensation on the petitioner, the stand of the government now to not to accept the payment of compensation to the petitioner, and for requesting the Deputy Commissioner to by impugn communication that you just complete the date of the communication, 2nd March 2026, is in violation of the legitimate expectation of compensation. Please issue notice returnable by 4 weeks, as Mr. M.S. T. Wang, Learned Counsel for the Learned State Council, appears to all the respondents.
Yes, ma'am.
All the respondents, no formal notice need be served. However, extra copies be furnished to the Learned Council for the Learned State Council.
All right.
Item number 3.
Right, Your Lordship.
Yes.
And this is again a case of land acquisition. The grievance of the petition is arbitrary reduction of the compensation. Well,
In respect of Mr. Modi, just for. What's the location of the land?
My lord, location of land is Chimpu, my lord. In this
Particular area?
particular area, the Chimpu, my lord. Now, initially, this land was for the, my lord, this hospital.
What is the measurement of land located?
Measurement about, my lord,
Have you
600,
mentioned in the petition?
my lord,
Located at Chimpu,
Malad.
land, when we say land, located at Chimpu. Measuring about?
measuring about, my lord,
264
264 square meter.
Near
MLA cottage,
MLA Cottage.
my lord.
Huh.
All right.
Yes, sorry, sir. You just said that when we said the land, encroached land located at so and so, measuring about at near MLA Cottage. Yes.
and after the preliminary notification for two laning of this highway, my lord, notification is at page 25.
Well, issue notice.
And only one aspect here. I'm just in short, I'm mentioning. My lord, initially, when the compensation was determined, compensation for my building was rupees 11 crore. It is a 5-story building, my lord. Then NHIDCL has raised objection in respect of some of the landowners. So far as petition is concerned, there is no objection. Specific serial number is given. There is no objection to my compensation. If your lordship kindly just goes to that, my lord.
Where is the reduction? We'll see.
Yes, only that much I'm showing. Lordship may kindly come to page 58 first, madam, straightway.
58.
Page 58. Completion report. আমাদের ভেরিটু 11 কোটি টাকার রিপোর্ট লেখা আছে 11 কোটি টাকার রিপোর্ট লেখা আছে Lordship, at page 58, Lordship will find it serial number 122. 122 LHS, that is LHS means left hand side. Then under the column name of the landowner is given by Dr. Sopai Tausik. Then Lordship, very important is area in square meter 632. Then the compensation has been given. Lordship, kindly see, so far as RCC building is concerned, the area of the RCC building has been taken to be 2066. Has your Lordship got, madam? 2066 square meter. Because there are 3-4 floors including basement and all.
Total area 632
Total area is 632. Then if your Lordship goes to the
square
column,
meters.
my lord. Then if your Lordship goes to this various heads under which RCC compensation has been given, RCC building, MS gate, RCC post, etc. So far as RCC building is concerned, in the fourth column, Lordship will find total area.
It's okay.
2066.
Issue notice what's there.
No, only one thing, madam. 2066 was there. Then the NHIDCL has raised objection.
It's okay. I've understood that
Madam.
earlier it was 11 crore.
It
Now it has been
brought down
reduced
3
to
crore.
3 crore.
Because there was no objection about my compensation. Still, they have reduced.
We'll see. That's why.
Now difficulties, my lord, in the reduced rate, they want to say, so far as building is concerned,
Where it is.
well,
Any order has been passed.
yes, my lord. If your Lordship straightway goes to page 155, my lord.
You are against this order.
155.
155. Any order has been passed.
Or yes, it has been now held to be 3. My lord, compensation I have taken under protest. Page 155, your Lordship, kindly seize, my lord. Last column.
When did you accept the compensation?
In the month of January, my lord, under protest. Now what happened, my lord, when I have written again to them, they have made another survey. And in the survey report, they say it will remain unchanged, nothing else, only that much.
So we will examine that.
My lord, Lordship is correct, no difficulty. My only thing is, my lord, so far, since they are reducing the area of building from 2066 square meter to square feet to 500 something, my lord. Now, whether the building, if the building is demolished, my lord, there nothing will remain for examining by your Lordship.
See, after the re-verification,
My lord.
they said you said that they said it remains unchanged. Unchanged means what?
That is the difficulty, my lord.
Earlier or
Yes, my
earlier
lord.
or
Well, that is my question before
present
Lordship,
one.
to the other side. That whether the earlier one 11 or it is 3. Just let them file a short or maybe oral instruction also, that will suffice, my lord.
any order has been passed for demolition.
My lord, now they are, since they are going ahead, they will demolish it, my lord.
No, any order has been passed.
Specific order is not there, my lord. But I am apprehending because that is why I filed a representation also.
It's okay.
Lordship will just protect me, let them take oral instructions, no difficulty, my lord.
No, it's very difficult. It's construction of road. You have already accepted the thing.
My lord, I have
We'll examine it.
After under protest, I have accepted.
It's all right. We'll examine it.
Now, my lord, if the building goes,
let the construction go on.
yes,
Not
madam.
stop.
If the building goes, let them keep a measurement of the building. Because they
No,
themselves have said,
what is there already in the record, we'll see. You are saying that the initial assessment
Was
compensation was
for
by providing as per the law,
yes.
by issuing a notice.
No,
left an
my
objection.
specific case is initially when they
And it is only on the objection of the NHIDCL
ICL,
that they have reduced it.
yes, but
without issuing a notice, without hearing you.
because, my lord, there is a reason. They have NHIDCL has raised objection in respect to some of the person giving names and their serial number. My name is, my serial number is not there. So there is no question of hearing me also. I was not heard also. Then while reducing,
Therefore, we'll examine that.
Yes.
On the basis of the
Yes.
records, nothing
But if
else.
the building goes, will they say
No,
that?
that's what I'm saying.
Yes.
Once you say that the initial assessment of 11 crore was as per the law,
Yes.
and reduction is in violation of the law without hearing you,
Yes.
without put to your notice,
My lord.
put on notice.
I am
So
also
examine on the basis of that.
But normally, I will also not pray for any stay anything because I ultimately I am entitled to enhanced compensation.
And yes,
Only one thing is, my lord, since it is
whether you are entitled for as per the records, as per the procedure, you are entitled for 11 or 3, we'll see.
yes, well, my only
On the
apprehension
basis
is,
of the record.
if the
nothing else.
building is not there, will there be a confusion as to what is the actual area of the building?
We don't know. Whatever they have done as per the records, we'll see.
They should keep record. That is what I'm saying, man. Otherwise, I'll not pay for any protection in the meantime. Because ultimately, it's a question of compensation.
Ultimately, it is the quantum of compensation.
Yes, yes.
Quantum of compensation.
Based on the area of the building.
Their own prayer that to refer it for to the reference court.
Where's the prayer?
And there is
Prayer
an
number,
alternative prayer, my lord.
Alternative prayer.
After
prayer
your
is
lordship
because
examines,
ultimately, whether he is entitled to the earlier quantum or
When this the remedy, you go
Yes.
there.
they have to
no, but
approach
that's what
the
I'm saying.
reference
You
But
file
that-
an application for reference.
reference authority.
That is under section 64, my lord.
Huh? You go there.
No, my difficulty is,
We'll,
if
we'll give you liberty.
my lord, if I go before that authority, it will take a long time. But
No,
it's very simple.
Sir, I cannot comment.
For early disposal, I have come before your lordship. my lord.
No, that cannot be. You withdraw, we'll give you liberty.
No, my lord, lordship may direct them. They just clarify why they have done this.
You
There was
yourself,
no objection.
sir, you know, you yourself has said there is alternative
No.
efficacy, not all alternative efficacies.
Well, I have said that.
Section 64.
Because I have said that.
You go there, if they don't entertain, you come back. We'll see. Just because it may take time, we
My-
cannot entertain. As you know, I just cannot.
If for efficacy, well, let them come. My lord, what I'm saying is, I'll go on the next day. My lord, next week,
No,
your
no,
lordship will
that
dispose
cannot be,
of.
sir. That cannot be.
Because
Will allow you to approach as per the in accordance with law, as per the provisions of law. Yep.
and I have already not that I have not filed. I filed only representations that kindly consider. From 2066 square feet of the building, my lord, 3-4 floors are there. They have come down to 500, lordship. On what basis? Nothing is mentioned. Nothing.
Anyway, that became something that can be considered by the authority.
My lord,
64.
My lord, authority. I'm just placing your lordship. Before the authority, if I have to show something to get my compensation enhanced, the matter is different. Here, building remains same. Floors are there. You have said 2066 square feet. Now you say it is 500. On what basis? Only that much.
That can be
clinch the issue.
No, that can be decided by authority.
But that can be. But they themselves have undertaken if they had not undertaken any revisiting, they have revisited on their own. That is why I'm before your lordship. Otherwise, if it is a simple case of enhancement, I would have gone mad.
Yes, this is a simple case of enhancement. Please go. Mr. We'll give you liberty.
My lord, your lordship,
The Majumdar, learned senior counsel, after arguing the matter at some length, fairly submits that he may be allowed to withdraw this writ petition with a liberty to approach the appropriate authority in view of the provision of section 64 of 64 of so and so,
of the right to
right
fair
to fair
compensation
compensation so
and
so,
transparency
2000.
in land acquisition, rehabilitation, resettlement Act,
M.
2013.
Ratan, learned additional senior advocate general is present for the respondents present. Accordingly, the petition stands closed on withdrawal with the liberty to approach the appropriate authority in terms of the provisions of
Section 64.
section 64 of right to fair so and so.
Lordship will kindly give me that liberty because there are some limitations, so they will accept my application.
No,
for
that's why
reference.
you got here. If any problem, you come back, we'll see.
Lordship, me just give an observation that they will consider my application.
Obviously. And needless to observe that in the event the petitioner approached the authority concerned,
Because there is a limitation period, they will consider liberally.
same shall be considered in accordance with in accordance with the law.
Lordship, me just mention that liberally they will consider the
No, in accordance with the law. That's all.
Otherwise, there is a time limit.
See, time limit award after the award.
After the-
when the award was passed.
Award was passed in January, I think.
6 months.
6 weeks. 6 weeks. Excuse me, very well. Lordship, me just mention that they will
In
consider my
accordance with the law.
liberally.
They'll consider.
That word will help the petitioner a lot. Since
No,
the
no,
Lord
we
is
just
disposing
cannot.
of-
We cannot pass the order, as you know that, which amounts to usurping the power of the authority,
Since I'm already there before a lot.
unless they are unauthorized. You are always come back. We'll see.
My lord. Obliged.
Item number 4.
How the writ will lie against this is writ petition.
Yes, Your Honor. Because, Your Honor,
See,
Lord-
Gawabura is an court now. I mean the authority of the court.
my lord, since revision is not live because he has not passed any decision. After issuing
Therefore,
third parwana,
there cannot be any writ petition against the judicial authority
my lord, since
unless it is in the administrative action. Judicial action cannot be.
my lord, since he is not passing any decision,
What can
so I can even approach through revision. He's just sitting over my complaint, not initiating to conduct cover.
you think about it, go through the research on it and come back. We'll close it with a liberty to file a fresh.
In that case, my lord, may it list tomorrow.
Huh?
May this matter be taken up tomorrow. I'll research tonight.
You research and file again. We'll see. Not Mr. M.
Your Honor,
Because this is against the head Gawabura.
yes, yes, my lord.
Under the Civil Courts Act, the village authority is a court now. Court of first instance. What do you call it?
Customary court.
Customary court.
My lord,
It's not
see,
an
after issuing three
it's
parwanas,
not an administrative action. It's a judicial action.
my lord, I thought of filing revision, but since he has not taken any decision, so writ
We're
is the
closing
appropriate.
it. You think about, you research it for 1 week and file it. We'll see.
Your Honor, my lord, matter may be taken up tomorrow.
Had Mr.
I'll
M
satisfy Your Honor.
and counsel for the, because we don't want to I mean, send a, not only want you to, we don't want to send a wrong message. Had it not been Civil Courts Act, matter would have been little different. There may be a gray area to go, I mean, deliberate on. But because of the Civil Courts Act, which has been recognized as the court, and the issuance of parwana and all this thing, not this way. You may file. I'm just indicating.
Okay, Your Honor.
Discuss with some of the experienced senior lawyers. All right, we're closing it.
Liberty
Had
to file a
Mr.
press.
Emmett learned counsel for the petitioner. No, not that. Mr. Emmett learned counsel for the petitioner. Petitioner submits that he may be allowed to withdraw this writ petition with a liberty to file afresh, if so advised. Writ petition. Accordingly, writ persistence closed on withdrawal with the liberty as prayed for.
Obliged.
Item number 5.
I'm just indicating you. Speedy trial. Find out. Yes.
May it please, Your Lordship. My lord, the petitioner is aggrieved by the inaction of the respondent authorities in not registering an FIR, which,
What is the latest judgment?
my lord,
Unless you approach there is the latest judgment of Supreme Court. Yes.
Huh?
You are a Lalita Kumar.
Lalita Kumari.
Very recently.
My lord. Regarding the approaching the authorities. Now, my lord,
Direct approaching
now,
the.
interestingly, what has happened here, my lord,
Hmm.
why I have filed a writ petition. My lord, as Lalita Kumari also indicates, if it is a corruption case, though it is illustrative, then the authority has to do a preliminary inquiry. And that approval has to come from the government. Now, the SIC requested the government for approval. Now, the approval, apparently, if your lordship will see how the approval has been rejected by the government. They did not consider my case, my lord. They took into consideration an earlier FIR, took note of that earlier FIR has been withdrawn, and therefore the approval has been rejected.
Have you filed a detailed affidavit?
Lordship, the detailed evidence has been filed, Lordship.
Huh?
Not filed, Lord.
Then?
Otherwise, records are. Otherwise, my lord, the affidavit which they have filed, if your lordship kindly comes to paragraph 5 of that
direction
affidavit.
to file detailed
Yes, there was.
Huh?
And the records also. I think your lordship's order is of 2016-2.
Yes, you file a detailed affidavit of records, you will see.
In that case, I will given some time.
That last time also, same thing.
Huh?
First it was 16-2, then 23, then 10-4.
And this matter is pending since 24, my lord, where, my lord, if your lordship finds the
Find out the latest judgment.
my lord,
The Supreme Court.
Yes. Now here, my lord,
Taken into account of Lalita Kumar also.
yes. That is, my lord,
Right.
perhaps that
Saying
approaching.
that approaching the High Court directly without availing the remedy to approach the higher authority under the.
No, we have lodged the complaint against the SP and the officer in charge before the authorities that despite our representation and the FIR being received by the officer in charge has not been acted upon. It has not registered. We have made this complaint before the higher authorities.
Where?
It was
Before the, as per the CRPC
yes,
or the.
yes, as per the result CRPC says if the officer in charge after receive it doesn't register it, then I'll have to approach this superintendent of police. If it is not done, then the complaint case. Now, my lord, will kindly see page 49. I did it before the special investigation cell and the chief vigilance officer comes chief secretary government of Arunachal Pradesh because that is the approving authority for initiating a preliminary inquiry. Now, Lalita Kumari says preliminary inquiry has to be done within 7 days. That's the time frame given. And my FIR was given on 5th of February 2024.
Latest judgment do you have?
I'll search for it. If lordship takes up after some time, I'll get it.
Not after some time. We'll once we have on the perusal of the affidavit, we find that the detailed
Yes.
affidavit needs to be filed.
In fact, the lordship
Yes,
took
heard Mr. B. Counsel for the petitioners, right?
my lord.
The learned state counsel, Mr. Ilman Senior Government Advocate, Mr. T. Tapin, has been granted an opportunity to file detailed affidavit after perusal of the affidavit filed on behalf of the state. However, today, Mr. Tapin, the Senior Government Advocate, submits that he could not file the detailed affidavit as directed.
Limited.
but had received the record. Next para, considering that this court, on procedural of the affidavit filed on behalf of the state, has directed the state to file detailed affidavit and to produce the record for the 2 weeks time as a last chance. 2 weeks time is granted to file detailed affidavit and to produce the record as a last chance. Mr. Opada Leonard, special PP for ACB is present. Who has to file? ACB or you?
Government. I'll be fine. Government.
You have asked for the approval. They have rejected it.
We have rejected. But may I pray for a fixed date?
Obviously, they'll reject it.
Well, can it be on 3rd of June?
3rd of June. 3rd of June, huh? Is it? It's audible. Okay.
On the 17th of
You decide.
17th June.
Okay.
Great.
Item number 8.
Please, Lordship, may I?
Yes.
Lordship, I'm appearing for the respondent.
Respondent of what?
Education Department.
Huh?
Education Department.
So,
on
we
behalf
are
of
not filing.
Yes, Lordship. As per instruction, we will file a counter affidavit.
When?
As we sought instruction.
How many days?
Lordship, for that 2 weeks time may be granted.
Heard Mr. So-and-so, learn, your name please?
D. Miu, my lord.
G.
Miu.
Mihu.
Yes, my
Learn counsel for the petitioner. Next para. On the prayer of Mr. Mr. T. Tagum, learned standing counsel education department for the respondent. Further, 2 weeks time.
Yes, ma'am.
2 weeks time is granted to file affidavit in opposition. List after 2 weeks.
Deeply online.
Item number 9.
Lordship, hearing of the matter is already done, Your Lordship.
Huh?
Hearing is already done, Your Lordship.
Already done.
Done, Your
That means, what do you want to say? What hearing? What do you want to say?
Your Lordship, on last occasion, 11, as per order dated 15/05/2026.
Of this court?
No, man. Justice.
Say, what do you want to say? You want to say that this has been part heard?
But actually, there is a civil dispute. This is a land acquisition matter.
No, it's not that. Just wait. Let us not go into the merit. What do you want? What is your submission?
Your
Sir?
Lordship, matter is already heard, Your Lordship. Hearing
Then
is already
what
done,
should
so
be done?
it should be fixed for order, Your Lordship.
Huh?
Matter should have been fixed for order, Your Lordship, as per order dated 15/05/2026.
Heard, Mr.
P. Wangpan, Your Lordship.
Learned counsel for the petitioner. Your name is there. Your name is there in the. Have you signed the wakalatnama?
No, it must be there, Your Lordship.
You don't know.
It's
can't-
there, Lordship. P. Wangpan.
T.
P. Wangpan.
It's there.
Okay, P. Wang Pang. Heard Mr. P. Wang Pang, learned counsel for the petitioner, and also not heard Mr. P. Wang Pang, learned counsel for the petitioner. Huh? You just did it. P. Wang Pang, learned counsel for the petitioner, submits that this matter has already been heard by the coordinate bench of this court. And the order could not be passed due to absence of the learned counsel for respondent number 3. Mr. MSP Sangeeta, learned government advocate, that is state counsel for the respondent number 1 and 2, and Mr. B. Picha, learned counsel for respondent number, standing counsel.
No, 3, respondent 3, private
Respondent number 3 are present. Next para. A perusal of the order dated 15/05/2026 indicates that the matter was heard. However, order could not be passed on that day due to absence of the learned counsel for respondent number 3.
Yes.
Mr. Considering above, let this matter be listed before the appropriate bench. We'll send it back because it's recorded. Matter was heard, order could not be because of your absence.
It was Ban Kolman.
Huh?
The day of Ban Kolman.
I don't know.
Item number 10.
It is lodged. In this, the respond number 5 has filed one affidavit. I would like to respond to that, my lord. To lordship, give me 1 week time, my lord.
On the prayer, Mr. B. Kaushik, learned counsel for the petitioner, a week's time is granted to file affidavit in reply to the affidavit filed by the respond number?
Respond number 5.
5. Next para, Mr. M. N. Ratan, learned additional advocation for respondent number
1 to 4.
1 to 4, and Mr. B. Soki.
Here, in item 10, I'm for respondent number 6.
5. Mr. K. Lawyer, CJC.
Private
counsel for respondent and Mr. D. Soki, learned counsel for respondent 6 are present. Huh? This after 2 weeks.
Can it be taken up on 3rd, my lord?
3rd.
I'll file it within 3
On
weeks.
3rd. Huh?
3 days.
And next 11. Same. 11. Same order.
Only
Here, my lord,
Here,
it would be respond number 6.
Here, K. Lawyer 6.
I'm for 5.
D. Soki 5. Same.
Yes, I would like to file reply to respond number 6 affidavit.
6. 6 affidavit. Here, huh? There will be just change will be this much.
Grateful, my lord.
Item number 12.
Yeah, your lordship. Your lordship, in this matter, I'm appearing on behalf of learned DSCI, Mr. M. Kato. Your lordship, we have not received the instruction yet. Your lordship.
yes, they have to file their affidavit.
Mr. You are appearing for? You are not there.
No, I'm appearing on behalf
Mr.
of
B.
JG.
Picha, Land Council for the Land Council appears
On behalf of JG.
appearing on behalf of Mr. J.J. Land Council for the petitioner is present. On the prayer of Mr.
T. Meto, your lordship.
Huh?
T. Meto.
T. Meto, Land Council appearing on behalf of Mr. M. Kato, Land
Yes, lordship.
BSGI. Further 3 weeks. 3 weeks time
Yes.
is granted to file affidavit of which.
Much obliged.
Item number 13.
May
You
it
have
please
been
your lordship.
appointed already.
We have been appointed. May it please lordship.
You want 2 years.
Yes, your lordship.
Why?
Lordship, the advertisement.
You are waitlisted candidate.
I was waitlisted, but
then-
the selected candidate, he refused to join.
Hmm?
The selected candidate refused to join. Thereafter, I had appeared. I had requested because I was in the waitlist serial number 1. Now they agreed
It's
to
a
appoint.
contractual appointment.
Contractual. Now they agreed to appoint me. The respondent number 2 has filed an affidavit saying that there was a negotiation with me, admitting that there was a
Who is
negotiation.
respondent number 2?
Member law.
Huh?
Member law of the commission.
Member law?
Law. There's a member, they call him member law. Is most probably from the legal background. So his affidavit is there. It clarifies everything. He says he admits that there was a negotiation.
The issue would be, as per the advertisement, it was 2 years.
2 years.
Whether you are entitled,
yes,
being a waitlisted candidate. Any judgment supporting?
The rules of the game cannot be changed, my lord. Rules of the game cannot be changed.
No, the game was already over.
Game was over. After that, they have tried to change.
Game was already over and you are not selected. But you have been given the appointment only just because you are a waitlisted candidate. That's all.
Yes, Your Honor. Your Honor, lordship is absolutely
regular appointment. It's a contractual appointment.
It's a contractual appointment. Lordship is absolutely
their own
right.
policy that you may not be fit. Therefore, they want that some IS officers or senior officers should be deputed.
Your lordship may,
in the interest of the commission.
Lordship may see the office note and the dates.
The office note were not interested.
In the affidavit of the respondent number 2.
It was for 2 years.
It was for 2 years, Lordship.
When did you, after the selection, after the appointment of how many months and how many days had elapsed?
Lordship, they did not even consider appointing me. It was only when I submitted the representation and I approached Lordships.
Because they once the selected candidate was not interested,
Lordship.
refused to accept.
Lordship.
Then they, because that time already selection process was over.
It was over.
They have decided to go for better secretary.
Lordship.
On deputation.
Lordship. Lordship, I was number 2. So when 1 goes, 2 comes into place. 1 is not there. So 2 is there. Now, for 1, the tenure cannot be different. And for 2, the tenure cannot be different. It has to be 1 tenure. In the selection process, the tenure is fixed.
When you are selected, you don't have an indefeasible right.
I do not have a right. That lordship is absolutely right.
So as any judgment,
lordship,
once it is once the appointment is for particular year as per the a particular term as per the advertisement, you cannot change it, even for appointment to the waitlisted candidate.
Lordship, I would rely on Manjusri.
That's not Manjusri.
Is on criteria. Is on criteria. Is on the criteria part. But
including the
waitlist is not there, Your Honor. In fact, Lordship, there are judgments that selected candidates do not have an indefeasible right. That Lordship knows. The selected candidates do not have a right. But what I am here on, my lord.
You are simply saying that as per the advertisement,
yes,
this tenure is 2 years?
Yes, yes.
Why 1 year?
And the other parts.
So as any judgment that once the tenure is fixed, in term as per the in the advertisement, you cannot change it.
Your Honor, I could not find a judgment specifically.
Manjusri says what?
Manjusri says the selection criteria cannot be changed. Manjusri as well as others.
Selection criteria.
Yes. What I would be on is it is not the selection.
Manjusri is that you cannot change the rule of the game.
Rules of the game cannot be changed. What I am on is the bigger picture.
That is referred to larger bench.
Then. Thereafter, it has been Manjusri has been upheld, Your Honor. There was another set of reasoning, but Manjusri has been upheld later on.
Manjusri and otherwise
Tej Prakash.
Tej Prakash and
Tej Prakash, Himani Malhotra. Tej Prakash says Manjusri has been upheld. Tej Prakash is.
You have the judgment.
Tej Prakash, I have, Your Honor, Lordship. Tej Prakash is the
Mr. So and so.
Excuse me.
PD Nair, learned counsel for the learned senior counsel, assisted by Mr. D.
No, my lord.
Who is assisting you?
She's
What's
Jimmy
your
Mamu.
Jimmy
Mamu.
Jimmy Mamu, learned counsel for the petitioner. This is Tej Prakash.
This is the larger bench judgment.
On reference. On reference.
Yes, lordship. On reference.
What is the
reference?
Relevant?
Manju's para 35 and 36 says Manjushri is good law.
35 and
36.
36. Okay. PD Nair, then senior counsel assisted by G. Mamu, learned counsel for the petition, and also
Respondent number 2.
respondent number 2. And Taje. Who is for 3? 1 in 3. What is it? What do you want to say?
Lordship is much aware. Nothing more to say.
No, I don't know anything.
Lordship, just for the interest and the safeguard of the public interest.
Why, once you have advertised for a particular year, 10 year, why you should reduce? Because she or he or she?
I'm he.
Hage Mima.
Yes,
you are he.
He
Or she?
He.
Okay. He has approached this court, therefore you have reduced their tenure. Right?
Actually, that is what has happened.
You are supporting his case.
My lord.
Huh?
Yes, my lord.
Why you are
Because
nodding?
eight party,
Madam, why you have nodded? He is supporting your case.
Yes, Your Honor.
That's why he's a party.
Oh, Your Honor, pardon me. I thought.
No, I am not letter not. It's okay.
After
I'll pass the order. He's supporting you. You don't have anything to say. Huh? That it should have been 2 years.
My lord.
Are you saying that the petitioner has approached this court, therefore you don't like him? So reduce the tenure and then ask for the deputation, officers from deputation. That's all.
But what they are relying on is a demi-office letter from the chairman to the government. And it is interpreted that it is the government's role.
But then let me
directly not apply, but
whether the
yes.
If the tenure in the advertisement, if the tenure provides even for waitlisted candidate, or it has to be in terms of the advertisement.
Yes.
All right.
Not. If I come across any judgment, I'll just pass on any other judgment on that. I'll pass on to the court.
I'll be passing the order. If you can do it today,
Lordship,
please.
Lordship. Deeply of that.
Pass the order.
Item number 14.
Well, here I appear for respondent 3 to 5. Will be requiring some more time.
David has not been filed
Competition.
yet, my lord. By invoking the emergency clause, my lord, that the land was acquired.
So I
Now-
think affidavit would be required.
That should be, my lord, but they are not filing anything, my lord.
Yes.
Let it be last chance, my lord. Because the rest of in a stretch of the road, my lord, which was acquired, my lord, the rest of the petitioner, some persons, my lord.
Your
Interested
land
persons.
must be behind those.
My lord, yes, my
land.
lord. It's a total stretch there, my lord. So the rest, my lord, some have been paid, my lord, last year, my lord.
Okay.
In July 2025 itself, my lord.
Okay. Heard Mr. D. Soki, learned counsel for the petitioners. Mr. N. Ratan, learned additional senior government, additional advocate general for the state respond, and Mr. So and so, T. Meto, learned counsel appearing for Mr. M. Kato, learned DSJ. For the 3 weeks.
Yes, madam.
3 weeks time is granted to file affidavit in opposition.
That's the last chance, my lord.
Last chance.
Malot, in fact, they will their affidavit will be more important.
Last chance. Last chance.
Instruction has not received.
You ask for the instruction. What's there? Your land has been acquired.
My lord, by invoking the emergency clause, my lord.
Acquired, but then
Yes, my lord.
payment has not been made.
Yes, my lord. The section 21.
According to you, what is there?
The stretch of road from 60 kilometer to 80 kilometer, that the
Land of the petitioner doesn't fall.
no, my lord, it has. They say that it has not been sanctioned because the DPR has not been sanctioned.
Then others they have paid.
No, this stretch from 60 to 80. There,
Those DPR, those
DPR, yes.
the other DPRs. I mean
that is those already in the DPR that has been paid. This stretch from 60 to 80.
Okay. So you will not construct this road.
60 to 80.
That is, my lord, contrary to the notification itself, my lord. That addendum was issued, everything was done, my lord.
So last chance.
It's the last time, my lord.
Yes.
Item number 16.
My lord, the respondent has yet to file the affidavit in this case.
What is the matter about?
This is a matter about, my lord, I was given officiating promotion to the post of trade development officer, my lord. And that was regularized, my lord. And that officiating was given on regular pay scale, my lord. And later on, they regularized in 2020, my lord.
From the date of DPC.
My lord, it was done through DPC, but my
from the date of DPC. Regularization.
Yes.
You want that it should be from the date of officiating.
Because my officiating service has to be taken into account, my lord, for the purpose of further.
What is the law?
My lord, I've mentioned the law of Saris Chahar Bhatia case also.
Which year?
It's year 1995, my lord.
No,
and also subsequent
2005 or first.
Subsequent also, my lord, is there.
2005.
2000.
Somewhere December, November, December.
My lord.
It should be from the date of DPC.
My lord, subsequent.
Although this court has passed some judgment contrary to that.
My lord, I'll just, that's, in this case, my lord, regular pay scale was paid, my lord. That is bit different, my lord, because had it been the case that I've not been paid a pay scale, that's a different thing. But I've been given pay scale. Now, if the length of service taken into account, but there's no harm, even there's no prejudice to the department, because I've been paid my.
But then you find out that judgment.
My lord.
That is judgment. It's nothing doing from the.
My lord.
You don't have a right to claim for retrospective regulation.
My lord, that
or the appointment.
My lord, that part, but I'll look into.
If you can convince, if you can distinguish that.
My lord, that part.
How many years you want to? I mean, how many months or days for filing affidavit?
2 weeks, my lord.
2 weeks. Heard Mr. T. Tagaplan, counsel for the petitioner. On the prayer of MS K. Wang, London State Council, further 2 weeks time is granted to file affidavit in opposition. Just after 2 weeks.
Deeply obliged.
Are you sure 2 weeks?
We have received a.
Okay, then 2 weeks.
Item number 19.
What is 19? What about 19? 19?
Item number 19. Yeah.
19, my lord, actually I have received the instruction, but I have forgot to file affidavit since, yes. Otherwise, I have a written instruction.
Okay.
So on 28th itself, all work about.
Everything finished?
Finished.
Executed?
Not yet executed.
Not executed?
Work order already issued.
What award?
Award on 28th, before filing of the.
What is your case?
My lord, the N.
2 days.
No. Yes, 2 days. There is a contradictory dates in the NIT itself. Now the NIT says that the.
No, what is your case?
Yes, that is what my case is. In the NIT, my lord, was issued on 24. It was published on 25. NIT says that the bid documents will be available for purchase from 26 to 27. Now 27 was the last date for submission. There was a mention of an address where the NIT documents will be made available. There was no such address available. We visited that place. We have found that there was no such office available for purchasing the bid documents.
That's your case.
That's my case.
There was no office.
There was no office. The
Where
office,
the office
they say some camp office,
Where?
some camp office at SEPA of the executive engineer, RWD Sanktazo. There was no such camp office. And second, my lord, if your lordship kindly come to page 25, my lord, the NIT. Page 25. My lord, this is 24.3. It was published on 25. Now, my lord comes to the serial number 2.
Camp office SEPA of executive engineer?
In the tabular form, my lord will kindly come to page serial number 2. Against the column, last date for sales of bid documents, 26.3.
26.3. Serial number 2?
Yes, serial number 2.
Is coming.
Is coming.
This is what? Strengthening and restoration of RCC returning while laying of...
I am eligible for this second class and third class firms. Therefore,
so
I would have been eligible for...
for sales of bid documents.
Bid documents.
26.3.
26.3. Last date of submission of bid documents, 26.3. And down below, my lord, if your lordship kindly come. In the bottom, my lord, the authorized tender documents along with the ITBP are available in the camp office SEPA, executive engineer Sayang Tazo from 25.3 to 27.3 up to 14 hours. And the date of opening of the bid was 27.3.
The authorized tender documents.
Yes.
Along with, what does the authorized tender documents means?
Authorized tender documents is the bid documents along with the ITB. And in paragraph 6 of my petition, I have categorically stated that on 25.3 and 26.3, the petitioner personally visited the office of the executive engineer's camp office, said to be located for the purpose of purchasing the tender document.
25 and 26.
26, on both the dates.
Para 6.
Para 6.
Yes, what is your instruction? Why 2 days?
Because it is a lapsable scheme. So if it is not put a tender, then it will lapse, bond will lapse.
So how many tenders, bidders participated?
Bidders, there are 6.
6 bidders?
Yes. There is document.
But then it would not be permissible.
Yes.
Even if it is to be left.
This is true, but
is there any provision that in the event the fund had to lapse, it has to tender has to be issued for even within for only for 2 days or 3 days?
That is some difficulties facing by the officer also. Since PON used to be sanctioned by 24, 25, then they are asked to implement the projects.
We understand, but we can't help it.
Some difficulties are.
You have to work it out. It will be the state policy. But reasonable opportunity has to be given. Minimum 14 days, right? As per CPWD.
Yes, yes, as per CPWD.
7 days.
2 days.
7 days.
7 days.
In terms
2
of the,
days is too much.
In some, only 1 day. 26 and 26 was the last day.
And he has visited your office. No one was there.
That part I can't say either. He visited.
Only para 6.
There can be.
You have received the instruction. No, instruction is you have received the status.
Yes.
Status. Not
that only 6 persons, 6 bidders, they have participated and the work has already been awarded. You are concerned about serial number 2?
No, they have said that.
No, I am concerned about serial number 2, 3 and 5 and 6. I would be eligible for only this.
2, 3?
2, 3, 5 and 6.
You are challenging all this?
Yes.
As per instruction, since Cheng Tajo division was newly carved out from Bameng, so Bameng division office is just Below the binet of the RWD SEPA, this stated office is there.
Then you said that the SEPA.
Yes, SEPA. Is in SEPA. Camp office in SEPA.
Where it is?
Just below the beneath the building of RWD SEPA. So
then why have not given that address?
No, they have
You
given.
simply say that camp office SEPA, something like that.
Yes, it was just before carving out from the bombing division. It was under bombing division.
Very difficult. Will interfere. Go for first tender. Are they party here?
Since there is private parties, they have not made party.
We don't have any information regarding the.
You take it from.
Yes, I'll make them a party.
Will interfere.
Yes.
They have to make party again since work has been already put.
I'll make them.
What's already been? You make them party.
Yes.
Let my senior friend provide me the names of the bidders.
Mr. B. Goswami, B. Kaushik, learn counsel for the petitioners. It is submitted by Mr. R. G. Tarak, the standing counsel RWD. That's on instruction. On instruction, it is submitted by so by Mr. G. Tarak, Land Standing Council, that there were 6 bidders who have participated in the tender process pursuant to participated in the tender process pursuant to the NIT dated 24. NIT dated
24
03/20
25/03/2026.
25/03/2026. No, the NIT dated 24/03/2026, published on 25/03/2026, and the and after completion of the tender process, the works in question have already been awarded to the successful bidders. On when?
That's also very
28.
interesting. He says 28. 27 was the date for opening the bid.
28/03/2026. Lister, next bidder. Considering above, let this matter be listed after 2 weeks. In the meantime, the Mr. Kaushik, Mr. Land Council petitioner may file an appropriate application for implement of the parties who have been awarded the work. We'll hear them and interpret and set aside everything. Set aside everything. Go for fresh tender. You take it back. Yes, madam.
There was an interim order, Miller.
Interim order passed earlier, shall continue. In fact, I wanted to dispose it of, but then problem is that the third party's right has
they will have to be heard.
Okay.
This interim order not to open the financial bid would be in practice.
Let it be like that, Miller, because on the date we made a submission. In fact, that was.
Item number 20.
The subject matter contents regarding the land.
Sorry.
Service report of the respondent for is awaited, ma'am.
Awaited. And counter affidavit?
Not filed, Your Worship.
You don't want to file?
Yes, we will not be filing, Your Worship. We are only formal party.
Okay. So we'll do it for some time.
Yes, for 1 month.
Mr. T. Land Counsel for the petitioner. Office note dated 19/5/2026 reflects that neither ID card nor unserved notice is received in respect of respondent number 4. Next paragraph. It is submitted by P. Sangita, London State Council, that the state, no affidavit is required. The state is not filing any affidavit, as the state respondents are only the performer respondents. Next paragraph. List the matter after 4 weeks. We'll say 4 weeks.
My lord, I may be allowed to take the dusty service. My lord.
And then you write, since the steps was taken on 13/02/2025, comma, as read for by Mr. T. Sir, and counsel for the petitioner, that a week's time is granted to take fresh steps
Yeah.
for service of notice upon respondent number 4.
With the provision to my lord dusty.
The steps by dusty mode, you just said, by dusty mode. This matter after 4 weeks.
Much obliged.
Pass over matter item number 1.
Yes.
Similar
order.
Yes, similar order. It will do.
Okay. Yes. Hard. MS.
MS
Your name, please.
K Yamak.
You have forgotten your name or what? Miss K. Yama.
Yamak. YAMAK. Yamak.
K. Yamak, learned counsel for the petitioner, and also heard Mr.
T. Kipa.
T. Kipa, learned standing counsel.
Yes.
CGST, what does?
It's a senior standing counsel, and it's CGST and CX.
Senior standing counsel.
Yes.
Senior standing counsel.
Yes, Lordship.
CGST standing counsel, senior standing counsel, CGST and CX for respondents. Next para. Having considered that the similar matter has been disposed of by the coordinate bench of this court, and also and as agreed to by learned counsel for the parties, this matter is the writ petition is taken up and disposed of at the motion stage itself. We'll pass the order in the chamber.
Highly obliged.
Dispose of.
Item number 21.
If it may please your lordship, my lord, the office note dated 19/5 shows that the service report in respect of some of the respondents are still awaited, your lordship.
All the respondents.
Not all, most of the respondents. And in respect of respondent number 20, your lordship, the notice has.
You take press steps.
Yes, your lordship. If your lordship allows, can I take?
Dusty.
Yes, otherwise through the head of the department, your lordship.
You may take it, Dusty. Had MS Dita counsel for the petitioner. Petitioners or petitioner?
Petitioners, your lordship.
Petitioner. Petitioners. Office note dated 19/05/2026 indicates that notice in respect of respondent number 20 has been received back unserved list of the learned counsel to the petition, and the service report in respect of respondent number 6, 7, 8, 10, 13, 15, 16, 18, 21, 22, 23, 25, 26, 27, 29 to 31 are still awaited. Service reports, reports are still awaited. MS is spread for by MS data council for the petitions. Service steps, press steps is allowed to be taken through dusty mode within 2 days, 3 days.
3 days, Your Lordship.
3 days, 3 working days. Mr. The Bitarak London Standing Council.
Yes, 1 to
RWP.
3. Respondent 1.
You are not filing affidavit.
Our affidavit is almost ready, but the annexure is not clear, so I am asking them to give eligible annexure.
Is phrase for it is granted 3 weeks time to file affidavit. List matter after 3 weeks awaiting service reports in respect of the aforementioned respondents.
All right.
Much obliged.
Item number 22.
May it please your Lordship.
Yes.
Lordship, on the last occasion, we had prayed for dusty service in respect of respondent number 8, 9, and 10, Lordship. And the same was already served, Lordship. However, inadvertently, we could not file dusty application, Lordship.
The Mr. D. Lona,
Lordship.
Land Council for petitioner is granted a week's time to file affidavit regarding the proof of dusty service upon respondent number 8, 9, and 10.
Yes, Lordship.
List after a week. MS the P. Secretary London State Council is present.
Problem.
All right.
Item number 23.
Yes.
Notice has been served, my lord. But as for office noting, service report is still awaited, my lord.
Award service report. List after
3 weeks, my lord.
3 weeks. Mr.
Techitopu.
Techitopu.
Yes, ma'am.
London Council for the petitioner is present.
Grateful, my lord.
Item number 24 and 25.
My lord, here we need time for filing of affidavit of opposition, my lord.
Yes. You are for?
My lord, I'm for respondent. IMC, my lord, for IMC respondent. Yes, my lord.
Heard Mr. D. Lona, London Council for the petitioners. You are for?
In item number 25, I'm for petitioner.
Mr.
Tigame.
Your name is not there.
25.
D. Lona, London Council for the petitioner in WPC 90 of 2026 and Mr. B. Tigame, Land Council, appearing on behalf of Mr. M. Ranka. M. Ranka, Land Council petitioner in WPC 114 of 2026 are present. Next prayer is prayed for on the prayer of Mr. El Kurdu, Land Council for the Land Standing Council IMC. Further, 3 weeks time is granted to file affidavit. Interim order passed earlier shall continue.
Item number 24 also, Lordship, interim order.
In both the cases. Interim order passed in both the cases. Still continue. Still continue.
Item number 34.
Thirty-four.
34. May please.
Yes.
Here we are challenging the termination pursuant to a disciplinary proceeding, my lord, on the ground of procedural lapses in the disciplinary authority, as well as the proportionality of the punishment that has been imposed. Now, my lord, the petitioner, he was appointed as a assistant cook at the household establishment of the governor's secretariat. Now, he was granted a leave, page 28, my lord will kindly find, for 19 days on domestic ground. There was a leave sanctioned, and he was supposed to join, as there was a 16 and 17 was a Saturday and Sunday. So he was supposed to join on 18. On 18 September 2023. On the next day, my lord, 18/9, my lord finds at page 29.
Are you ready?
Page 29, he filed an application for extension of his leave on medical grounds. And this was received by the authorities on 18/9/2023, down below, my lord, we find.
Yes.
The receipt acknowledgement. Now, after he has resigned, he was never been informed about the outcome of this extension of leave application. Whether it's allowed, rejected, it was never been informed. After he has resigned, purportedly the authorities have constituted a medical board and examined the medical documents of the petitioner, which was submitted along with his extension for leave. Now, page 30 is the so-cause notice. May I just read page 30, Miller?
Yes.
Well, page 30 is the so-cause notice dated 2nd of November 2023. Whereas Sri Jitendra Prasad Assistant Cook's Governor's Secretariat was granted earned leave for 19 days with effect from 28/2023 to 15/9/2023. And whereas, while approving the leave of Jitendra Prasad in his personal file, the authority directed that no extension of leave will be entertained for any reasons. Now, look, this direction apparently was in the personal file, but this direction does not contain in the order where the leave was granted. Page 21/8 was the leave sanctioned order. Page 28, if your lordship finds, there is no such mention about this direction by the authority.
19 days.
19 days.
Earned leave for 19 days.
Earned leave for 19 days. And that order, my lord, finds at page 28. And in that order, there was no such mention that no further leave would be granted.
Which one?
Page 28 is the order of granting him earned leave for 19 days. Page 28, based on the recommendation of the so-and-so, Sri Jitendra Prasad Assistant Cook, Governor's Secretariat, he is hereby granted earned leave for 19 days on domestic ground.
It's okay.
Yes. Now, in the so-cause, the authorities took a plea that in the file noting there was a direction that no further extension would be entered in for any reason. Second,
Memorandum?
my lord?
Memorandum of charges?
Yes, the memorandum of charge is at page 35.
And then
for so-cause, I replied to the so-cause notice.
Yes, then
the articles of charge, lordship will find at page 36. Two charges. One, unauthorizedly overstaying beyond the sanctioned leave and by his willful absence from duty without any intimation. Now, this without any intimation is incorrect because he on the next date of on the date of his rejoining, he submitted an extension for extension of leave to the authority and submitting medical documents only to extend leave. Jitendra Prasad violated Rule 311, Roman 2, Roman 3, Roman 6 of the CCS conduct rules. Second articles of charge is that frequently fails to perform his duty as per the requirement of the post. He lacks sincerity and dedication to the duty. Jitendra Prasad Cook has violated Rule 312, 3 and Roman 6 of the CCS conduct rules. Now, my lord will kindly come to the statement of imputation at page 37.
Yes.
Sri Jitendra Prasad, Assistant Cook, Governor Secretariat, was granted leave of 90 days from while approving the leave of the Jitendra Prasad. His in his personal file, authority directed that no extension of leave will be entertained for any reason. The contrary to this direction, Sri Jitendra Prasad applied for commuted leave for 28 days with effect from 16/9 to 13/10 in continuation to the 19 days early. So he applied for an extension that is not disputed. The medical board was constituted by the senior medical officer to this office by letter dated 13th October to scrutinize his case. The medical board submitted his report on 19/10/2023. I'm allowed to kindly see the report of opinions of the medical board, Miller. As per the medical board report, his SGPT and SGOT readings in the biochemistry test performed on 14/9/2023, that is 2 days before he consulted OPG on 16/9/2023, were abnormally high and they do not correlate with his symptoms presented at the OPD. The medical board got his test conducted on 17/10, in which his SGPT readings are within normal range. The medical board has opined that it would at least take 3 months for these values to reach some normal level, but in case they reach normal level range within a month. That under normal circumstances, if a person falls ill, he first consults a doctor and then undergoes a various tests as advised by the doctor. But in his case, biochemistry test was performed on 14/9 and he consulted the doctor in OPD in Meerut Hospital 2 days later on 16/9/2022. That he was not hospitalized for treatment but treated only as an OPD patient despite such high values of SGPT and SGOT. As per medical practice, 4 weeks medical leave in a single go is not prescribed. Repeat medical tests are performed in a week or two and then decision is taken. No such repeat medical tests are performed in this case.
Inquiry report.
Inquiry report, I'll come. Now, my lord, against this articles.
Report was served to you.
Yes, it was served to me. The inquiry officer took up opinion, gave an opinion that I have confessed my guilt, but there was a denial to that, my lord. My lord, comes to page 38 for a moment, my lord. This would be relevant because I have been allegedly charged for violation of Rule 25 of the CCS Leave Rules 1970.
Okay, how this is what the inquiry report says?
Yes, inquiry report.
You have participated in inquiry report.
Yes, yes, sir.
Then
I have submitted my reply. The inquiry report says that there were 2 dates of hearing, but I have denied, my lord. No hearing was afforded to me. Inquiry report starts from page 44. Down below, my lord, will find.
The official has pleaded guilty to charges spread against him, which corroborates with the document have been placed and against the findings of the charge solely for extension, which is further substantive findings of the board considered by CM of the warning letter to. Yes, where you have in the inquiry, what is the statement?
My statement?
Yes.
Not even recorded.
Where you have said, on what basis they are saying that you have pleaded guilty?
That's what, my lord. In my reply to the inquiry report, as page 48, lordship comes to page 51, paragraph 4.
Date of hearing, so and so. List of exhibit, findings of medical board.
Among the list of, my lord, there was one more thing. They relied on a report of a.
For treatment, but treated only as of the dispensers have released SPG change review.
Page 47, the conclusion of the inquiry officer, my lord. He took note of two things, my lord. One, my confession, and the other one, Exhibit 13. That Exhibit 13 was also never a part of the relied upon documents in the memorandum of charge. So no opportunity was given to me, and that document was never been served upon me.
From what they are saying that you have you have accepted the charges.
They, I don't know where from they are saying.
What is your statement?
My statement at page 51, reply to the inquiry report.
Not the inquiry. In the inquiry.
No, inquiry, they have not said anything. Where is my statement? If whether the statement that I have submitted accepting my guilt has to be a part of the record.
Any statement?
No.
Made by you?
No, I never. In fact, when the inquiry report was served upon me, at page 51, my lord, to come to page 51, my lord.
I'm never pleading guilty for any reason.
Yes.
As I have a willing done to explain for country or no exception to consider my premises funding of committee. This is what?
This is my reply to the inquiry report.
Okay.
When the inquiry report was furnished to me. If my lord is pleased to come to 47 once more, my lord. Page 47 once more, my lord. The conclusion of the inquiry officer.
Yes, I have seen that.
Yes. There, my lord, the inquiry officer also took note of one Exhibit 13. That Exhibit 13 was never a part of this memorandum of search or the show cause, my lord, which was issued.
You have been dismissed from service.
I am dismissed from service with prohibition for future employment.
Obviously. If you are dismissed.
Dismissed with disqualification for future employment under government.
See, if you dismiss it, then it need not be mentioned.
Hello?
Is it required to mention?
Yes. It may be a dismissal without a disqualification for future employment and dismissal with disqualification for future employment, because CCS rule provides both the punishment.
Yes. Page
47, my lord will kindly come. (46), my lord, first. 46. The
Exhibit 11. Exhibit 11.
Exhibit 13. Discussion regarding Exhibit 13, page 46. Page 46. The findings of the medical board constituted by CMO PL Sharma, District Hospital, Meerut, Uttar Pradesh on medical ground, medical documents issued by Dr. Anu Gupta to Sri Jiten Prasad, charged official. Medical document issued by Anu Gupta has been issued under some influence to give undue benefit to the patient. Dr. Anu Gupta, whose appointment is on contractual basis, is not authorized to issue medical certificate independently and was warned earlier as well as not to issue medical certificate, but in spite of that, she has done it. The present medical board agrees with all the findings of the earlier board constituted with regard to the examination of the medical certificate. Now, I'm allowed to kindly see this. Contract appointment has been concealed in the seal, thereby misleading the patient. So where was the fault which is attributed upon me? Now this officer, the one aspect which the inquiry officer took note of, that the authority, the medical officer which has issued the certificate was a contractual employee, was on a contractual appointment, and therefore she did not have the competence to issue the authority certificate. But there is no finding that the
findings of the medical board placed as Exhibit 11 makes it amply clear. What is the
Exhibit 11 is a medical board report of trims. Now that your lordship will find at page 45, the findings. And those findings are also based on conjectures, my lord.
Report.
Not conclusive.
Findings of the board constitute CMO PL Sharma.
There were some queries put by the authorities to the TRIMS.
No, from where they are saying that you have accepted.
Well, I don't know, because that's even the original records are there with him, because the inquiry officer requires to maintain a proceeding, the minutes of every day of the hearing. That record will show whether I have submitted any
There's no
statement confessing.
witnesses. No
But
witnesses were examined.
no witnesses were examined.
Except the
Only the documents
and the presiding officer.
and the presiding officer,
Presenting.
presenting officer.
Do you have the records?
Yes, Your Lordship.
You have the records?
Yes, sir.
Okay.
Even in a affidavit also we have annexed the,
Records.
yes, records.
The statement.
No.
No, Your Lordship, the daily order sheet, Your Lordship.
Is there any examination of the thing?
Your Lordship, if I may take Your Lordship to our affidavit, Your Lordship, 110.
Not affidavit, I'm just asking. We'll go through the affidavit. It's okay.
Yes, Your Lordship. Yes, Your Lordship.
Anything to show that he has accepted?
Yes, Your Lordship.
the
We have
charges?
asked some questions.
Where? During the course of inquiry?
Yes, Your Lordship.
Hmm?
Yes, Your Lordship. It's in our,
Any witnesses were examined
no, Your Lordship. Witnesses, no, Your Lordship.
except him
Yes, Your Lordship.
and the presenting officer?
Yes, Your Lordship.
But inquiry report doesn't indicate except the conclusion. When this statement was recorded?
It was on 14/3/2024, Your Lordship.
14/3.
Yes, Your Lordship. Page number 110 of our affidavit, Your Lordship.
Just wait.
March 2024, Your Lordship.
First day.
Yes, Your Lordship, first day.
Okay. We'll come back to you.
Well, break. Hold on.
Please proceed.
Well, now if your Lordship kindly finds the report which has been relied upon at page 45, the findings of the Medical Board of TRIMS on queries related
Exhibit 11.
Exhibit 11.
Yes.
The queries, they have recorded the queries and the observation of the medical board. First query was that under normal circumstances, if a person falls ill, he first consults the doctor and undergoes various tests as advised by the doctor. But in this case, his biochemistry tests were performed on 14/9/2023 and he consulted doctor in OPD in Meerut 2 days later on 16/9/2023. The present medical board totally agrees with the above observation that under normal circumstances, a patient gets tested only after consulting a doctor. A patient with such severe symptoms and abnormal test report would normally never consider delaying his own treatment intentionally. Query 2. That he was not hospitalized for treatment but treated only as an OPD patient despite such high values of SGPT and SGOT. Now observation, your Lordship will kindly find. Ideally, any such patient with fever, acute abdomen nausea, and vomiting with severe jaundice and tachycardia should preferably be admitted and managed and further investigated appropriately in healthcare center. Example: LFT, KFT, electrolytes, CBC, viral marker, and ultrasound of abdomen with an emphasis of hepatobiliary system in absence of
You
such.
make your submission.
Yes. Now, my lord, this observation of the medical board was not conclusive. They has given a general opinion as regard the standard operating procedure that is being followed. Now, my lord, your lordship knows the SGPT and SGUT. Nowadays, my lord, every person.
Go into that.
Yes, yes.
Make your
Yes.
not conclude.
First of all, my lord, the authority took into consideration the medical board, ignoring the fact that there was a certificate issued by the medical officer whose competence has been seen into, whereas Rule 19 of the CCS conduct rule says, my lord, if it is a non-gazetted employee, even an honorary officer, medical officer, can issue a medical certificate. So that competence that the medical officer was a contractual appointee and was not competent to issue an authority certificate does not falsify the certificate, my lord. There is no finding of the inquiry officer as to that this certificate is fabricated and it was falsely manufactured by the charged official. There is no finding to that effect.
It's okay.
My
That
lord.
I understood.
Second, my lord, the findings of the medical board of merit, that is Exhibit 13, which has also been a consideration for giving a conclusion by the inquiry officer, that Exhibit 13 was never been served upon me. Exhibit 13 was never a part of the relied upon documents in the memorandum of charge. So in my respectful submission, my lord, taking consideration of that Exhibit 13,
But
without
Exhibit 11 was there.
Exhibit 11 was there. Exhibit 13 was never a part of. Exhibit 13 has been taken into consideration to see that the medical officer who has issued the certificate has issued under my influence. Now that Exhibit 13, taking note of, without giving me an opportunity of being heard and without supplying that copy, well, the inquiry is vitiated. Second, my lord, if my lord finds the order of termination now. The order, my lord, my reply.
Before that, whatever the acceptance.
My lord, I have denied that. I have denied that in my.
After the inquiry, that is obvious. But this is a statement on 14.
Yes. No, after the inquiry, because.
No. On 14/03/2024,
my lord,
you accepted.
No.
There is a statement.
My categorical statement is that, my lord, I have never accepted the charges. What I was being told by the authorities that if you tender your apology, sign this, tender your apology, we'll consider the dropping of the charges.
Then
and under that pretext, my signature was taken. I have, my lord, your lordship will kindly see.
Difficult.
I am an assistant cook. I am an assistant cook who doesn't understand English.
That cannot be.
And my signature is in Hindi.
Statement.
Yes.
Let us see.
In my writ petition,
Page 110, your lordship.
110.
Annexure N. The proceeding.
110.
Yes, your lordship.
Where is the statement?
No, your lordship.
Second up in the office chamber of division, have you received the charge sheet? Have you received? Do you accept?
Paragraph
the charge
9
sheet?
of my
Since the
writ petition.
judge pleaded and has accepted in principle. Has directed the president to submit a brief for concluding the read over the judgment. Yes. Who is this? Jitendra Prasad.
He is the petitioner, your lordship.
Do you accept the charges?
No, my lord.
Yes.
Paragraph 9 in my writ petition, I have categorically stated that.
110.
But that's what in paragraph 9 I have explained in my writ petition.
Your explanation, the writ petition only do.
My lord, understand, my lord, that I am an assistant cook who is facing a departmental proceeding. The authorities who are superior to me.
I may understand. Law may not understand.
No, my lord, because in response to my inquiry report, where they have taken my confession, I have denied to that.
Inquiry report.
My lord,
obviously, that is obvious. After the inquiry, when you were found guilty, I mean, the charges are proved.
No, my lord, how between the inquiry.
Anything else?
Your lordship will kindly take note of this, my lord. First, my lord, to kindly come to page 11, paragraph 9 of my writ petition, my lord. Under what circumstances this signature was obtained, I have explained that.
Page 9.
Paragraph 9, page 11.
Paragraph 9, page 11, WPC.
Yes, my lord.
WP.
Notwithstanding the petitioner's hearing, he was effectively denied the opportunity to present his defense and instead was coercively persuaded to acquiesce to the charges, ostensibly to facilitate the imposition of a minor penalty and mere warning, purportedly due to his being a first-time offense. The petitioner, as an assistant with limited proficiency in English language, encountered considerable difficulties in navigating the inquiry proceeding conducted by his superior officers. Furthermore, the petitioner was not afforded opportunity to cross-examine any witnesses who may have been testified during the purported hearing. In reality, the hearing was a mere facade, designed to create an illusion of procedural compliance, whereas in fact no genuine hearing took place, thereby violating the principles of natural justice. So my categorical case is that, my lord, and lordship will read this with page 51, my lord. After the inquiry officer has given an inquiry report, taking my confession into consideration, page 51. Page 51, paragraph 4. Page 51, paragraph 4, my lord, now say. Paragraph 4, that I have never pleaded guilty for any reason as I have a valid ground to be explained for my continuous unauthorized absence from my duty and good reasons to be considered my prayer, and as such, finding of the committee against me is biased and baseless against me. So, my lord, the day when my signature was taken, I was given a pretext that a minor charges would be, and your lordship will kindly see, your lordship will kindly appreciate. Well, is this punishment so not harsh for a 28 days leave, unauthorized absence? And my lord, the inquiry officer also did not came to a finding, there is a judgment of Honorable Apex Court which I will be relying, my lord, that there is no finding with regard to my willful absence.
Once you accepted the charges, what more?
The acceptance of charges by an assistant cook who has no proficiency in respect of the English language. Hello, your lordship will kindly see my signature is in Hindi.
You don't have the proficiency in English language, and you can reply in English.
No, that's reply is being
saying that I have not pleaded guilty.
In fact, my lord, the replies, your lordship will kindly appreciate one thing, my lord. The replies that was drafted and my signature in the reply is also in Hindi. It is not that, my lord, I have signed it in English.
Can you do same thing? Reply English
and lordship
and sign in Hindi. The statement you have made.
That was
when you were question were put to you. You said yes. You accept the charges. Yes.
My lord, that has been denied, my lord. During the inquiry proceeding, my signature taken by an authority on the pretext that a minor charges would be imposed if you accept it.
Okay. Judgment? Any judgment?
Yes. Now, my lord will kindly come to the termination order, my lord, first.
It's okay.
My lord, that's important.
On
because
no,
my lord. Apart from
the of the inquiry report.
No, my lord, apart from the inquiry report, the disciplinary authority takes into account some past conduct which is never a question of charge, which was not never articles of charge. To arrive at a conclusion that there was a devotion of duty. Now, my lord, I have been charged for willful absence and devotion of duty.
So,
now to conclude, to hold me guilty for devotion of duty, the authorities at page 56, para 18, takes into account certain past conducts which was never a part of the inquiry, my lord.
Para 18.
Para 18 and 19.
Yes.
In past also action was taken against him for such misconducts. While Sri Jitendra was posted at Governor's Camp, Arunachal Pradesh, New Delhi, a notice was served to him for not fulfilling his responsibility. The notice was served on dated 9th June 2014. A memorandum was served on 1/6/2020 for leaving his duty place willfully without any sound reason and failing to discharge his duty. Warning letter was issued on 15/6/2020 for resorting to instruction given by his superior controlling officer and asking for a written orders as to duties he has been assigned and at which place. Hence, there is an abundant evidence which shows that he frequently fails to perform his duty as per requirement of the post. He lacks sincerity and dedication to duty, thereby violating rules and so of the conduct rules. For this finding also, Jitendra Prasad has not submitted any cause and comment despite numerous opportunities given to him. Now, I will kindly come to the articles of search. Where is this allegation a part of the inquiry, Miller? My lord, come to page 36 is my articles of search.
I've seen that.
Yes,
Okay.
and your lordship will also come to page 39, the relied upon documents.
Which judgment you are relying? That's all.
Yes,
Okay.
my lord will kindly come to page 39 also. Take note of page 39, the relied upon documents.
It's okay. Page 39 of?
Page 39 of my writ petition, which are the documents which was furnished to me.
That you have said so.
List of documents. And this documents at paragraph 18 and 19 are never a part of the list of documents.
But fact remains that your notices were issued.
Well, how would I reply to this, my lord, if I have not been so caused? This has never.
It is not only the ground.
No, that's the ground for holding me not for devotion of duty. Because for devotion of duty, your lordship will kindly appreciate. My dismissal can be only if I am held guilty for devotion of duty.
What judgment?
If your lordship will kindly take the CCS rules for a moment, Miller. Rule 25 of the CCS conduct rules. Well, there are two charges against me. One is violation of CCS rules 25 of the CCS leave rules.
You want to take holiday or what?
No, well, look, I'll take just 10 minutes. The judgment which I'll be relying, I'll mark the paragraph, my lord. I'll not waste your lordship time, my lord. If lordship comes to
Rule 20?
Rule 25. My first article of charge is violation of Rule 25 of the CCS.
1965.
My lord, CCS leave rules 1972. If your lordship is holding the same book, it would be page 785.
785. Something different.
My lord, your lordship is holding this book. Central Civil Service leave rules 1972. ये बुक है क्या? इस साल का
This way.
It's I think your lordship book would be 821. The rule starts from 821. Yes. It would be 836. 836, my lord. fines.
This is the rules 72.
72.
Rule?
Rule 25.
It is the rule. Absence after expiry of leave.
Yes. I have been, my article of charge 1 is violation of this rule. Now this rule, my lord, what is the consequences of violation, my lord? Unless the authority competent to grant a leave extends the leave, a government servant who remains absent after the end of the leave is entitled to no leave salary for such period, for the period of such absence, and that period shall be debited against his leave account as though it were half pay leave to the extent such leave is due, the period in excess of such leave due being treated as an extraordinary leave. So, my lord, the at best for the consequences which I could have been, the punishment which could have been faced is no leave salary. So in that context, my lord, I'm making my submission, my lord. The dismissal with a disqualification for future employment is shockingly harsh, my lord. Now coming to the article number charge 2. Article charge 2 is in violation of Rule 3.1, Rule 3.1, Rule 3 Roman 2 and Rule 3 Roman 4. Now, my lord, this rule of the conduct rules imposes
CCS conduct rule.
Yes, my lord. CCS conduct rule 1964. Now, my lord, second charge is
Absent the second charge.
yes, second charge is for violation of this 3.1 Roman 2 and Roman 4.
3.1
3.1 3 Roman 2, Roman 3 and Roman 4. Now, with regard to this violation, my lord, which I have read, my lord, the disciplinary authorities, paragraph 18 and 19. For holding me guilty for this violation, my lord, the authority has relied upon paragraph 18 and 19. The findings of the authority is paragraph 18 and 19, which apparently was never a part of the inquiry, and they have taken note of the past conduct, for which I have never been so caused. So in that case, my lord, my respectful submission is I have not been given an opportunity to answer this allegation which has been taken into consideration by the disciplinary authority while imposing the punishment, my lord. And my lord, in such context, my lord, I'll place certain judgment, my lord. One is, my lord, I'll be relying that the inquiry officer, there was no finding. Disciplinary authority, they have not given any finding that there was a willful absence. The Honorable Apex Court says, if the allegation is willful absence, there has to be a categorical finding of holding me guilty for willful absence.
Judgment.
My lord. For willful absence, it is 2012 3 SCC 178, my lord.
SCC
2012 volume 3 SCC 178. I'll be relying on paragraph 16, 18, 17, 18, 19 and 20, 21.
17 to 21.
17 to 21.
Yes.
And 22 also, my lord.
Then
sorry, my lord, 24 also, my lord, take note of. On the challenge to the proportionality of the punishment, my lord, I would be relying on
B. Parmer's case.
2006, volume 6, SCC 794.
Era
Here, paragraph, my lord, 13, 14, 15. And one recent judgment, my lord, it's paragraph 10. It is 2025 Supreme within bracket SC 1515.
Era
Paragraph paragraph 10, my lord.
That's all.
That's all, my lord.
Yes.
My lordship.
Any judgment you would like to rely?
No, your lordship.
You don't want to make any submission.
Your lordship, since he has admitted his fault, your lordship,
He said he has not admitted.
in his order sheet, your lordship, in our annexure 110, your lordship, he has clearly admitted. And regarding his paragraph 9, your lordship, wherein he is saying that he doesn't understand in English.
And what
Here-
about the para 18 and 19 of the impugn order? You have not relied on, you have taken some grounds
Yes, your lordship.
which was not part of the memorandum of charges.
No, your lordship. If you see the article charges, your lordship, in Article 2, your lordship, it is written that Jitendra Prasad, assistant cook, frequently fails to perform his duty as requirements of the post, your lordship. This is that, but in his reply, he's silent about this Article 2, your lordship.
Then you have relied some documents
Yes, your lordship.
which
It's
was not
documents.
given to him,
Yes,
was not a part of the documents which you have relied during the discipline proceedings.
but your lordship, the medical certificates that he has brought along with his extension of application leave, that very certificate was declared void by the concerned universities of the Meerut University and all yours.
That you have not furnished to him.
That your lordship, in that your lordship, yes.
Any judgment? No.
No, your lordship.
Suppose if it's the forget about for the timing, this admission part you forget about for the timing.
Yes, your lordship.
Suppose if he's found to be unauthorizedly absent,
Yes, your lordship.
then dismissal would it entail dismissal? Is it not harsh, too harsh, or disproportionate? Dismissal.
Off the record, yes, your lordship, but
Okay. heard Mr. B. Kaushik, learned counsel for the petition, and also heard Mr. Wairidam, learned state counsel for the respondents.
All respondents, Your Worship.
Hearing concluded. Judgment reserved.
Grateful, my lord.
Obliged, Your Worship.
Highly obliged.
Item number 35.
Just wait.
Made to.
Yes.
My lord, the petitioners are aggrieved by the cancellation of the NIT dated 8/1/2025. That has been done in the most arbitrary manner. Without the reason assigned is that my bids are abnormally high, whereas my bid is 44 lakhs 78,480 rupees below the estimated cost put to tender.
44?
78,480.
480.
Yes.
What is the
estimated cost put to tender was 365, 75,000. My bid amount was 320,96,520. 320,96,520.
520.
Yes.
Yes.
Take your lordship very quickly through the facts. There's not much to it. At page 52 is the NIT.
Is 52.
My lord will kindly have the third column. Estimated value of contract. This is issued by the FCI. 3 crores 65 lakhs 75,000 only. This is an estimated cost, estimated value that they have put it, not me.
Road transport contract.
Yes.
Yes.
Then, my lord, this is a trading license, so I'm skipping all this. I submitted my bid. There were subsequent facts, but ultimately they allowed me. Your lordship will come directly to 165. Next year 4.
165.
Yes. There were 5 bidders. I'm at the bottom, MSTT Enterprise, qualified. 3 qualified, 2 disqualified. This is from online generated from their website. Because they did not give us anything, not even the minutes of the bid opening also.
3 bidders qualified.
Yes.
For technical.
Technical, yes. Then your lordship will see next page, 166. TT Enterprise, total price 320 such L1. First one, remember?
60.
166. Very next page.
Yes.
L1, 320,96,520. That is an amount which is less by 44 lakhs 78,480 to the estimated value they have put. 44 lakhs.
Yes.
Yes. Thereafter, on the next page, no information, nothing. In the website, that declares the status cancelled.
Page 167.
Annexure 6. Just cancels it.
Yes.
At the next page is my representation.
This is dated 18/3. Then 169, they issue another tender for the same route, my lord. But this is only
Cancellation was on which date?
cancellation, my lord. They don't even have a date here. No, 167. Yes. This is from the auto-generated website.
Okay.
We represent at 168. 169, my lord, they issue another tender. This is on ad hoc basis for 3 months only. I participate. In fact, I qualified in this. I was awarded this contract, the temporary one. We filed the writ petition also earlier, challenging that. Your lordship will find at page 220. The interim prayer was not granted. Thereafter, at page 224, another NIT was issued. Now re-NIT, re-tender.
224.
Yes.
Where is the order?
Of this honorable court. At 220. Notice was issued. No interim was granted. There's interim in this case now. Two to four is the fresh NIT. Same work, estimated value, same. Till such time, my lord, I have not been communicated anything. This is dated 25/3/2025.
Oh, fresh NIT.
Yes, this is what we have put to challenge. Now, by way of an IA, they have sought leave of this court to cancel this tender. So this is gone now. The only issue before lordship now is whether they could have arbitrarily cancelled the earlier NIT. This is gone. They have cancelled it themselves.
They have cancelled this?
Yes.
Because that tender was expired, my lord.
Whatever it is, they have cancelled it.
Yes.
So this is no
With
longer an
the
issue.
leave of this honorable.
Yes. The challenge to the
leave was granted.
Yes.
To cancel.
To withdraw, my lord.
Withdraw. You have
scrap,
withdrawn.
to scrap, yes, my lord.
Withdraw, cancel, or
To scrap, my lord. To scrap the NIT.
So the challenge to this does not remain anymore.
Okay.
We have challenged it. The
So
fresh
issue is
tender.
whether
We could have done it.
So you are waiting for the outcome of this writ petition.
Yes, my lord.
That if we find that the cancellation was not proper or illegal, then you have to award the work to them.
Yes, my lord.
If not,
So this is, my lord, you kindly
you will go for fresh tender.
Yes.
Yes, my lord.
Okay.
Kindly note, my lord, this is 25/3/2025. Since we assailed this on 5/4.
Any order of scrapping or something like that, cancellation. You just tell the date.
Passed in IA number 307 of
No, on when? When?
Yes, my lord. I'm just finding out the order. IA 307.
No, thereafter. Have you passed any specific order?
Date का आगे देख.
That is 3/2/2026, my lord. So interim order was also modified. No steps shall be taken by the FCI to go for a fresh NIT.
Okay.
My lord will kindly note the fresh tender was 25/3/2025. That is how arbitrary they are acting, my lord. I have not even been informed despite being the lowest bidder. since we challenged it, by way of this communication, 5/4/25 at page 237, this is what they have communicated. My lord will kindly see now. 237, last page. Man. After the retender and which I put to challenge, thereafter. With reference to your letter dated 18/3/2025, it is to inform that rates cited by your firm in the financial bid were very high, and awarding the contract at the rate would have caused huge financial loss to the government exchequer, my lord. How can that be, my lord? They have fixed the estimated value of the tender at 3 crore 65 lakhs. I bid 3 crore 20 lakhs, 44 lakhs. How can it be, my lord, abnormally high, my lord? These are the facts, my lord. My humble submission is, my lord, this is totally arbitrary. There is the reasons assigned
were very high.
Yes.
My firm in the financial bid were very high, and awarding the contract at the rate would have caused huge financial.
I did not fix the estimated cost. They fixed it. How can my bid, that is 44 lakhs, 78,480 rupees below the estimated cost put to tender, be high? Because the estimated value of the tender, they have fixed it.
This ad hoc one was L1.
That was awarded to me, yes.
He was also L1. You were also
Yes, there also I was L1.
And the ad hoc also the petitioner was the L1, but the rate was, my lord, much lower than the regular tender, my lord. In the regular tender, it was 4520 per metric ton. And in the ad hoc, the petitioner himself quoted 3990 per MT, my lord.
What does that matter?
That 45
how can this be very high and
yes,
very high?
That, my lord,
I was
that
the L1.
certifies that the rate was higher, my lord. Thereafter, subsequent ad hoc was, my lord, called for. There, the rate was 2,800 only.
By whom?
By another L1, my lord.
Which another L1?
I will find it out, my lord. In the subsequent ad hoc tender, my lord.
First ad hoc tender, he was awarded.
Petitioner was awarded at the quoted rate of rupees 3990 per metric ton.
Then next.
Then the next was second ad hoc was on 2,800, my lord.
Before that, you have decided to cancel.
My lord, yes, my lord.
You have cancelled. When did you cancel it?
We have cancelled on the, my lord, on 17/3/2025.
17/3.
And I have the list of dates, my lord. That will be easier to follow, my lord.
Just wait. 17/3.
17/3/2025, my lord.
You have cancelled the.
Was cancelled, my lord.
Tender.
Thereafter, the petitioner.
When was the next ad hoc tender?
21/3/2025. After cancelling.
I'm passing on a list of dates.
21/3.
2025.
So therefore, how can you say that? How you can cancel it?
My lord,
before you came to know that they've quoted, I mean, lower rates.
Because we have compared.
Absolutely, my lord.
My lord, because we have compared with the other route, my lord.
See,
to come to the conclusion.
See, where compare, you are saying that they have quoted in the ad hoc tender, they have quoted much lower rates, but quoted the higher in the earlier
regular tender.
Regular tender.
Regular tender.
You have
Nostradamus.
17/03/2025.
Yes, unbelievable.
And quoted the ad hoc tender on 21.
Yes, my lord.
Right. How can you compare with that? Is this absolutely afterthought?
No, we have not compared with the subsequent tender, my lord. We have compared with the other route. We have stated in our affidavit, my lord.
No. What do you say? The tender said that your firm in differential were very high and awarding contribution. But the ad hoc tender was plotted for Samson by Division so.
Yes, after cancelling,
yes.
my lord, after cancelling, we have called for.
Funds quoted by your firm in the so regular tender.
The reason they have given is only after they get the tenders in the provisional tenders that have subsequently. How can this be a reason?
That's what I'm saying.
Absolutely absurd, my lord.
My lord, we have compared it.
In any case,
Maybe we could understand, can understand that you want to reply this. Therefore, you don't have the reason.
yes.
Therefore,
My
you
lord, we have
taken
the reason, my
ground.
lord, we have stated in our paragraph.
No, your affidavit will not do. You have yourself.
This is a public order.
Because, my lord, we have compared with the other route, my lord.
That they cannot
you
do.
might have that you have not said.
That
so in
cannot
your,
do. That they cannot do.
communication.
In the
In your communication, you have not said. so, sir.
that is true, my lord. That we have not stated, my lord.
So that, as you know, you cannot be improved by your case by filing the affidavit.
In any case, my lord, how can they rely upon rates from other routes? I am not finished. How can they rely upon rates quoted in respect to other routes? This is respect of Koloriang. My lord, no, there are different terrains here. You cannot compare the route somebody quotes for Namsai and Miao.
Which route they have?
I don't know. Let them say it. I think it is Namsai and Miao. How can they compare them?
We'll come
If
back
I
to
am
you.
allowed.
We'll come back to you. We'll come back to you.
Yes.
Yeah.
So, my lord, in my humble submission, this communication is an afterthought.
This is
It's an absolute afterthought which they could not have done. My lord, I agree,
This
my
is
lord.
ground
They can,
only.
yes,
this is
this is the only ground.
reply of your representation
Yes.
regarding submission of tender document. 18th May you have filed.
Yes,
Cancellation 17.
yes.
But you didn't know the date of cancellation.
That is not there, but I have given in the list of dates, my lord.
Ah.
17, 18, I submitted fresh NIT on 21. On 24/3, I filed the earlier writ petition.
Okay. Yes.
My lord, first of all, the petitioner is stopped from filing this writ petition, my lord, because in the earlier round of litigation, my lord, that is WPC number 123 of 2025, wherein the petitioner has challenged the cancellation and also prayed for an award, giving an award to the petitioner in pursuant to the tender dated 8/1/2025. After cancellation, we have issued the ad hoc tender, wherein the petitioner has filed the WPC number 123 of 2025. Challenging the ad hoc tender where the interim order was not granted. After having found the allowance, having got the award, my lord, in the ad hoc tender, the petitioner chose to withdraw that earlier petition, my lord, without taking the liberty. My lord, the similar prayer was there in that earlier writ petition also, my lord. My lord, the earlier order is at page 286, my lord, of my affidavit in opposition. 286 is the first order of where the interim order was not granted, and page 290 is the withdrawal order by the petitioner, my lord.
Just see. Page
290.
290.
Upon instruction, Mr. O. Pada, 290. Learned counsel for the petitioner seeks to withdraw this writ petition. Prayer is allowed. Accordingly, the matter stands dismissed on withdrawal, my lord. So liberty is not taken, my lord. So that closes the prayer which were earlier made in the earlier writ petition, my lord, challenging the cancellation and also praying for the giving the award in person to the 8/1/2025, my lord.
This is of
My lord, 289 is a party name. WPC number 123 of 2025.
what is 285?
285 is the first order, my lord, in the WPC number 123 of 2025, where the prayer for interim was not granted, my lord. So the authority awarded opened the tender, my lord, and the petitioner was found L1. So and he was awarded the contract. After getting the award, my lord, the petitioner chooses to withdraw the earlier writ petition without taking the liberty of this honorable court, my lord.
No, challenges the what? Which
in the earlier writ petition, it was same thing was challenged, my lord, the cancellation of the tender dated 8/1/2025, which was cancelled on 17/3/2025, and also prayed, my lord, that writ petition is also tagged with this case, my lord, and also prayed for awarding the contract in person to the earlier tender dated 8/1/2025, where he was also L1, my lord. So that is my first case, my lord. ground, my lord. Now, my lord, para 15, page 260.
कौन सा वाला एफिडेविट को आप पढ़ रहे हैं? कौन से पेज से स्टार्ट होगा?
नहीं, इसके बाद में एक और एफिडेविट.
This is, I'm not able to connect it. Just can first ground, can you?
My lord, in the rate petition, there the prayer.
हाँ, second बोलिए.
So you are challenging, your submission is that the present rate petition is not maintainable.
He is stopped from challenging again, my lord, having not taken the liberty of this honorable court to challenge the again if required, my lord. Because once he has got the, my lord, tender, my lord, awarded the tender in the ad hoc, he chooses to withdraw the earlier writ petition challenging the same thing, my lord. That is 123 of 2025. Thereafter, when we have called for the another regular tender after cancelling the earlier one, my lord, earlier 8/1/20, we have called for 25/3/2025, where the interim order was granted by this honorable court not to take any coercive action. So, my lord, after we have filed our affidavit in opposition, this matter was admitted for final hearing. So today is the matter is for the hearing, my lord. So I will just refer to 2-3 paragraphs, my lord, then I will end my listing back. My lord, page 255, my lord, of the affidavit in opposition.
Para 5.
Para 5, my lord, where this ground was taken, my lord, that after the instant writ petition is not maintainable in law in as much as the petitioner is stopped from challenging the cancellation of the NIT dated 8/1/2025 in view of the fact that in earlier round of litigation filed by the writ petitioner, that is WPC number 123 of 25, the petitioner had challenged and paid the same relief as made in the writ petition. That was, I have argued, my lord. Now, my lord, next paragraph 6, my lord. Paragraph 6, 256. May I read it, my lord?
Yes.
That I say that the FCI respondent have for the first time has invited NIT dated 8/1/25 for appointment of road transport contract Harmuti FSD Bandardeva to Colorian via way bridge for the entire distance. The said route to Colorian is the new route for the FCI, and the said NIT dated 8/1/2025 was floated for the first time. However, the FCI received the rate of 4520 per MT as L1, which was seemingly on higher side. Therefore, the FCI respondent took a decision to cancel this said NIT dated 8/1/25 and call for the ad hoc NIT dated 21/3/2025 as floating of regular NIT would take another 3 months for finalization. I further say that the reason behind for cancelling the said tender has been taken based on the various grounds. The FCI has full authority to explore the possibility of getting the competitive rate decision has been taken as per the clause 4.4 of the FCI contract manual, which is quoted here in below, my lord. The second paragraph, the reasonability of the tender rates, my lord. While examining the reasonability of offer rate should be done in absolute terms of the rate MT with nearby other existing FCI, other PSU discover tender rate and prevailing market rate for similar services. Prevailing market rate be obtained just prior to the opening of the technical bid. So, my lord, in this case, we have taken the rate from Bandardeva to 0, my lord. Next paragraph, I say that as per the said clause, the reasonability of quoted rate was examined by the authority by comparing the rate with the nearby other existing rate and prevailing market rate for similar services. Furthermore, the majority of the contracts were awarded at the rates below the prescribed market rate for the respective area. The petitioner's allegation that the rate quoted by him in the NIT dated 8 is lower than the PMR or that the estimated contract value is unfounded as the rates approved by this office in any contract are already below PMR received. It may be pertinent to mention herein that the transaction audit report made by the FCI Journal Office Northeast Guwahati, it was observed in para 3 under heading L1, rate awarded at higher than 19.5% of the previous contract in the first attempt as follows. The previous rate of the regular contract was rupees 2,800 per MT and the L1 rate for the awarded contract was 3,346. Thus, the accepted rate of the contract was 19.5%. higher than the previous contract, no attempt was made by the management to go for the second attempt so that the lower rate could be obtained. So this is an example where the journal office has taken an exceptions to that, that having awarded the contract with higher than the 19.5%, my lord. That was, therefore, it can be seen that the strong exception was taken by the journal office that no attempt was made by the management to go for the second attempt so that the lower rate could be obtained. Further, the clause 11 under the heading General Information to Tenders stipulates that the FCI reserves the right to reject any or all the tenders without assigning any reason. Therefore, I say that there is no malafide or arbitrariness or discriminatory illegality unreasonable or perverse and capricious as alleged by the petitioner. The decision of FCI in cancelling the NIT dated 8/1/25 is just decision, and the said decision is fortified by the fact that in the said ad hoc NIT dated 21/3/2025, the FCI had received rupees 3990 per MT as compared to NIT dated 8/1/25. This has saved the corporation and the public exchequer to the tune of rupees 38 lakhs. Thereafter, my para 15.
Yes.
Para 15, my lord. Page 260, my lord.
That I have read it.
Last line, I say that upon evaluation of the price bid of the NIT dated 8/1/25, the tender was cancelled as the rate of L1 of rupees 4520 per MT was seemingly on a higher side. I further say that the MTF clauses under General Information to the Tender Clause 11 stipulates that the FCI reserve the right to reject any or
Para 17.
yes, para 17. That 1, 2, 3 earlier repetition has been referred. Then, my lord, page 266, my lord. Para 22, my lord. I say that, maybe did, my lord. I say that the estimated value of contract is based only on assumption which varies from tender to tender and is not a guaranteed value. Further, as mentioned in foregoing paragraph 15, L1 rate for the ad hoc rate was 21/3/2025 is rupees 3990 per MT for the entire distance, which is rupees 530 lower than the L1 rate of the 4520. Hence, if the said rate of 3990 per MT would be continued for 2 years, it would have saved an amount of rupees 38 lakhs. My lord, and now lastly, my lord, I want to refer one paragraph, my lord, where the rate was compared, my lord. Page 344, my lord. Rejoinder affidavit to the petitioner affidavit in reply, my lord. 344, my lord. Only one paragraph. In this regard, I say that, para 10. In this regard, I say that for any existing or expired contract, estimated value of contract is calculated on the basis of the work done in the previous contract. Whereas in case of the new godown or warehouse to be operationalized, estimated value of the contract is assessed by taking into consideration the quantity to be handled or transported and the prevailing market rates for that particular work. All examples cited by the petitioner in this case are falling under the category of existing expired contract. Hence, the comparison with RTC coloring is incorrect and not tenable. Then, my lord, down below, I further say that since it is a contract of the new route, the estimated value of the contract cited in the NIT cannot be inferred that quoting the rate lesser than the estimated value of the contract guaranteed the bidder to win the contract with the higher rate. It may be pertinent to state herein that the food storage depot at Colorang is a new depot and there was no previous road transport contract from railway head Harmuti FSD Bandardeva to FSD Colorang. The decision of cancellation of NIT dated 8/1/2025 was arrived upon after comparison of rates with the interest with the nearest depot available, and the comparison may be seen as under. So next page is the chart, my lord. It has been only been compared with the Harmuti to 0, my lord. Thereafter, from 0, the coloring route will come, my lord. So only one, Harmuti to FSD, my lord, that is 105 kilometer, and the rate per kilometer was 18.9. And the prevailing market rate was 2750, 2750 and rate comparison, L1 rate comparison is 30.55% lesser. Now the present Harmuti to FSD Colliery, my lord, which is 227 kilometer, which was quoted by the petitioner was 4520, which comes to rate per kilometer would be 19.91. So, my lord, it is only 12.23% lesser than the only lesser, my lord, 12. So we want to show, my lord, that in the Harmuti to zero, the prevailing market rate, it was 30.55% lesser, my lord. Whereas in this Harmuti to Colliery, only 12.23% lesser. So by comparison, the FCI, the authority has decided that it is at the higher side, which is fortified by the fact that, my lord, the petitioner himself quoted 3990, my lord. Earlier, he has quoted 4520. Thereafter, that was the tender for 6 months, my lord. Thereafter, another ad hoc tender was floated, my lord, where the rate came down below, my lord, that is 2,800. The next paragraph, my lord. Only this paragraph I want to show, my lord. I say that, may I read it?
Page
346, my lord.
46.
I said that FCI is a subsidy-based organization and runs on the exchequer of the Government of India, and saving of rupees 390.44 per MT is a saving on the exchequer of the Government of India. Be it mentioned herein that the L1 rate in case of RTC 0 is 30.55% lesser than the prevailing market rates, whereas L1 rate in case of RTC coloring is only 12.23% lesser than the prevailing market rates. So there is more likely chances of getting lesser rates in this route. The decision of cancelling the tender was only for getting a competitive rate for the new depot. The L1 rate received in ad hoc NIT dated 21/3/2025 is rupees 3990, and the rates received in the second ad hoc tender dated 26/7/2025 our L1 rate are 2800, L2 rate is 3820, which is much lesser than the petitioner himself, my lord. L3 rate is also, my lord, lesser than the petitioner's earlier quoted rate, my lord. So in the second ad hoc was 2800, my lord.
Forget the first and second, forget it. How you have compared the market?
Compare, my lord, that with the, we have compared with the Harmuti to zero, my lord. After crossing zero, then another 100 kilometer, my lord, 115 kilometer coloring will come. So we have compared it with the nearest one, that is in that route, my lord, Harmuti to zero, my lord, which is 105 kilometer.
It's up to zero or what?
Up to zero, my lord.
No, no.
Harmuti to zero is 105 kilometer. And thereafter Harmuti to Colliery, my lord.
Contract is up to zero or what?
No, my lord, to Colliery, my lord.
Then
now in that route we have only Colliery, my lord, FSD. Up to zero we have a FSD. This FSD has been taken up, a new FSD, my lord, at Colliery, my lord, to for PDS system on that area, my lord. So beyond zero there is no FSD.
The contract is for up to Harmuti to
no, my lord, up to Colliery, Harmuti to Colliery, my lord.
Then.
So that's why, my lord, we have compared it with the Harmuti area, my lord, because same route, half the route is same, my lord. After crossing zero,
I think it's not.
This is the stand of the authority.
Unjustified.
So, my lord, we want to rely on three citations, my lord.
Why three? Citation is not required.
Only one, my lord, then. The state may not accept the offer even though it happens to be the highest or lowest bidder, my lord, Air India Limited, my lord.
It's all settled.
There are 7, my lord. Only one, my lord.
Air India.
Air India. There are 7. Second was the Jagdish Mandal. May I read it?
It's okay. Cochin International.
So that is my humble submission, my lord.
1, 2, and 3.
Yes, my lord. Judicial review of administrative action, my lord, by Jagdish Mandal.
And
this
then
NG case where the interim order should not be granted when he can claim damages, my lord.
interim order is over.
Yes.
Third one.
My lord.
NG project. Third one.
Third one is the NG project.
NG project. Not relevant.
Not relevant now. So I
And
heavily rely on 1 and 2, my lord.
1 and 2 are certain position. not
Yes, my lord.
dispute.
Yes.
Yes, my lord.
If it is arbitrary, your lordship should always interfere.
Yes.
Can I, my lord, clarify that estoppel one, my lord?
Yes.
I have not understood why my learned friend keeps harping on that. The
Have
writ
you
petition was
said-
filed.
In your writ petition, have you said that it was withdrawn with the liberty to file?
No, I don't need a liberty because there's a fresh cause of action.
Yes. Petition was filed?
Yes. Petition was filed, my lord, after the cancellation itself and the floating of the ad hoc tender. No entry was granted. I participated. That is only for 3 months. Now, once this new NIT was issued for the same route, there was a fresh cause of action. 25/3/2025. I withdrew it on.
We do it on
7/4. After the fresh NIT. Where's the need of a valid liberty, my lord? The fresh NIT was issued. Even the provisional was also put to challenge. But once the fresh NIT issue was issued for the regular route, then the earlier writ petition in fact became infructuous.
No, once you have challenged the cancellation
Yes.
in earlier writ
Yes.
petition,
Yes.
then you have withdrawn it.
That was only cancelled and ad hoc was issued. Subsequently, when this fresh NIT was issued at page 224, there's a fresh cause of action. So I refiled it. That was withdrawn. I did not need the liberty for that. Once the fresh NIT was issued, not the provisional one, 25/3/2025, for the same work, same route, there was a fresh cause of action.
But essentially, the basic challenge was the cancellation.
No, the provisional also. Here, my lord, this is also under challenge. The 25/3/2025. My lord, will kindly just
See,
say, supposing
when the
once this NIT was issued.
regular tender was cancelled,
Yes.
tender process was cancelled, although you were found to be L1,
Yes.
then thereafter they issued a
Provisional
ad hoc or provisional tender
Yes.
for 3 months.
Yes.
You have challenged that, including the cancellation.
Yes.
Right.
Yes.
Thereafter, you have withdrawn it.
Yes, because subsequently they issued a fresh tender. (25/3).
It's not on you being awarded the provisional tender.
No, that is different, my lord. There's a fresh tender now. The provision was for only 3 months. Once this fresh tender comes, new cause of action arose, my lord. Absolutely, my lord. Once the fresh NIT was issued, it's a new cause of action.
But Port Shepherd said you could have prayed for liberty.
That is there. But in my humble submission, my lord, say supposing, my lord, there's a contempt proceeding going on. In the meantime, my lord, they passes an order. I don't need the liberty, my lord. Your lordship always say, what is the need for liberty? It's a fresh cause of action.
Okay.
And my lord, regarding the route, my lord, your lordship knows. Bandar to Zero cannot be compared for Bandar to Colorian, different terrains. But I'm passing on some judgment, I'm not reading it. Regarding cancellation, my lord, I put Kamdhenu cattle fields, I am relying. Paragraph 7 onwards.
There you have, I think, already given.
I gave earlier. This was earlier hard ones. Yes. And regarding, my lord, giving regions trying to improve their case, 1952, 1952, my lord. Commissioner Police Delhi. I will kindly see, they have given an estimated value of the tender. I am supposed to bid in respect of that.
Just wait. Madam, have you put my last note in that CAD? Last note. No, this.
Cancellation cannot be arbitrary.
Where? This is
7, 8, and 9. 10 also, madam.
This Kamdhenu.
Kamdhenu, madam. 7 to 10.
7.
7 to 10, my lord.
Other one is?
Other one is, my lord, paragraph.
Das, Banji.
Yes. Paragraph 9, my lord. Para 9.
Why don't you cite the Mahendra Singh Gill, MS Gill?
This is the first one, my lord. This has been followed. This is the
Para
first.
9.
Yes, para 9.
This has been relied there only.
No, this is 1951, my lord.
No, this has been relied in this thing only.
Yes, yes.
Mahendra Singh.
Yes, yes.
Okay, then.
That's it, my lord. My lord has seen the reasons given, and my lord, the manner in which they have done it. They did not assign any reason. Only after, my lord, I filed the writ petition, my lord, they have assigned the reason. They too taking note of the tender as submitted in the provisional tender, temporary tender, ad hoc tender. How can that be a ground?
Okay. Had Mr. Deepangi, learned senior counsel assisted by MSD, learned counsel for the petitioner, and also had Mr. BK Singh.
BK Singh, my lord.
Learned standing counsel.
Standing counsel.
FCA for all the respondents.
All the respondents.
Hearing concluded, judgment reserved.
Oblige, my lord.